Please, Your Honor. In item number 46, I have filed a dusty affidavit that may be called for your lordship. Deeply obliged.
Lord, I beg to mention 19, 20, 21, Lord. My senior friend has some difficulty, Lord. There is urgency on his part. But I'm praying, Lord, this matter can be taken immediately after reopening, Lord.
My lord, first of
19.
all, my lord, this matter at their instance, it has been fixed today. And the position of adjournment is dismal in this case on the part of respondent number 1. And my lord, we are the employee of the erstwhile T stage. Now, our, my lord, the arrears salary provident fund, that all has been stored. And one of the employees, my lord, he is in the deathbed. Because the paucity of fund, my lord, he could not go for good treatment also.
Mr.
Urgency
Doctor,
likes
it
to-
is not possible to do the cases today also.
My lord, in that case, my lord, can I make a prayer to fix it on 14th, on which date my learned friend will
Yes,
not
ma'am.
make any prayer?
Okay, Mr. Dubey, you are for
Petitioner, Lord.
petition in which? Okay, 18. Item 18, 19, 20, 21.
19, 20, 21, I am.
18, Lord.
Okay. Mr. R. Dubey, learned counsel for the petitioner has made a prayer for adjournment, full stop, of the case, full stop. Mr. S. Doctor, learned senior counsel for the respondent number 7, 6, 7, and 8.
6, 7, and 8.
For petitioner in 6459, 18.
6, 4, 5.
Mr. S. Doctor, learned senior counsel for the respondent number 6, 7, and 8 in the 18. And Mr. Your A.R. Pal, learned counsel for the petitioners in 19, 20,
And 21.
21 are present. Full stop. Mr.
Item 18, I am for respondent 5.
Okay, Mr. A.K. Sahwala, respondent number 5 in 18. To the prayer of Mr. Dubey, learned Mr. Doctor has expressed urgency in the matter. Full stop. In that view of the matter, as agreed to and sought for by the learned counsel for the parties, release the cases on 14 or 16. 14.
Not
The interim order needs to be extended
Interim order,
in item 18.
if any passed earlier, shall continue till the next date.
Keep
of
to
Wherever passed earlier shall continue till the next date.
Obliged.
That is the concern of the other side. I beg to mention item number 38.
30.
38. We need to file reply, lordship. 2 weeks time may kindly be permitted.
Okay, Mr. S.K. Saha, learned counsel for the petitioner, has sought for and is granted 3 weeks time to file an affidavit in reply. It is submitted that consent has been taken from the learned counsel for the respondents to make the prayer. Raise the case accordingly. After 3 weeks already to fix by the office. Any interim order?
Yes, ma'am.
The interim order, if any, passed earlier, if any, shall continue till the next day.
With the consent of the other side, lordship, I beg to mention item number 35, lordship.
35.
We'll be filing our reply affidavit, lordship. I am for respondent number 9.
You want to file
Yes,
affidavit?
yes, lordship.
You have informed the other side.
Yes, lordship.
Okay. Mr.
K. Mujumdar, lordship.
K. Mojumdar, learned counsel for the respondent number 9, has sought for and is granted. How much time you need?
4 weeks, lordship.
Okay. 4 weeks to file an affidavit in opposition on behalf of the said respondent. It is submitted that consent has been taken from the learned counsel for the petition and other respondents to make the prayer. The prayer is allowed for you. Release the case after 4 weeks and take 2 weeks by office.
Meet please, Your Lordship. Lordship, I beg to mention item number 26. 26 to 33, these are connected matters.
26.
Yes, Lordship.
Okay,
26 to
tag
30.
matter or similar matter? Yes.
Lordship. Lordship, I'm praying for 3 weeks time to file affidavit. I'm for the respondent.
Lordship, you're for the.
Mr. A. Kaushik, learned counsel for the petitioner is present. So what is same likibo? Miss
A. Pradhan,
A. Pradhan, on behalf of,
Mr. S. Chetia, Senior
okay,
Standing
learned
Counsel.
counsel on behalf of Mr. S. Chetia,
S. Chetia,
Senior
Senior Standing Counsel of
Standing
Income Tax.
Counsel, Income Tax Department for the respondents has sought for and is granted. How much time?
3 weeks.
3 weeks time to file counter affidavit on behalf of the respondent income tax department authorities. Lays the case on so and so. Silo, August 22nd. Any interim order?
Lordship, there is a interim order.
Interim order passed earlier shall continue till the next date of listing. Same order in 27 to 33.
26 to 30.
26 I have passed the order, same order.
May I please your lordship, my lord? My lord. May I please your lordship, my lord? I beg to for listing for withdrawal, my lord, tomorrow, my lord.
I beg to mention item number 11, Your Honor. Kindly adjourn this matter for the day.
11,
Yes, Your Honor.
you want adjournment?
Yes, sir.
Okay, on the request of
A high.
A Highland Council for the petition. The case is passed over for the day. Mr. N. Dasler, engineer, my advocate, Assam for the status money is present.
Obvious.
May I please your lordship, my lord? I beg to mention for urgent listing of two motion item tomorrow, my lord. Matter relates to eviction, my lord. Obliged.
Daily list for motion, item 1.
My lord, due to confusion, I have not implemented collector Kamrup in the lead petition.
Heard Ms. D. Roy, Land Council for the applicant.
So I
And
filed it.
Mr. This is to be allowed first. This is to be allowed first.
Yes.
Applicants and Mr. N. Das, learned junior government advocate for the respondent number 1 and 2, opposite party number 1 and 2. Full stop. The applicants.
1, 2, 4.
We are impleading now.
I'm pleading here.
The applicants, as the writ petitioners, have preferred the accompanying writ petition WPC number 2825/2026. Seeking inter alia direction to the respondent number opposite party, the respondent number 1 and 2, to make payment of the debt claim as per a judgment and order passed by dated 29/6/2013, passed by the Motor Accident Claims Tribunal, Kamrup, Gauhati in MSC, case number
Kamrup.
554/2009. Post of para. The instant application has been filed by the applicant's writ petitioners seeking impleadment of the following authority. 4 number to the collector so and so. As party respondent number 4 in the accompanying writ petition, post of para, it is averred that for adjudication of the issues raised in the accompanying writ petition, come on the presence, the proposed party respondent is necessary. The proposed party respondent is a necessary party. And in that view of the matter, his impleadment as a party respondent in the accompanying repetition is necessary. Full stop. I have gone through the statement and some environments made in the application, as well as the issues raised by the applicants and petitioners in the accompanying petition. Full stop. As the proposed party respondent, it is appears to be a necessary party for adjudication of the issues raised in the accompanying petition. The instant application is allowed. Full stop. The learned counsel for the applicants, petitioners is to file a amended cost title in terms of science. So within 2 working days from today, on such filing, it will be raised to carry out of correction. So after correction, the accompanying petition is to be listed in the motion column accordingly. It will come. File the amended cost title.
Yes, sir.
Item 2,
My lord, instruction received. It says, my lord.
instruction review.
Could not be proceed, my lord, due to deficiency of documents.
Documents are deficient, but I will.
But you have to pass a region order.
They have not rejected my claim. They are not proceeding. How they will indicate the documents which are required, I will submit my note. Accordingly, they will consider.
Two things are possible: PAN card
Mine.
of buyer, seller,
Fine.
non-encumbrance certificate,
Fine.
co-patadars NOC, NOK, and affidavit from the buyer. These are possible to be supplied.
That apart, malab, if any other documents are required, malab, I will submit.
So I can indicate that if any, apart from these documents, any other documents is necessary, then the petitioners, buyers and sellers will submit, but that has to be informed in writing. This is verbal. This will prolong, unnecessary prolong all these issues. Yes, we can do it. But all are same.
3, 4.
So
All are
2,
same.
3, 4, my lord, in item 3, my lord, it says that as per application. of-
Different instruction. Different instruction.
Different instruction.
Okay, one by one.
No,
then
no,
it will
no, no,
raise.
4 is almost same.
Okay, anyway, I have
First, my
to
lord, yes.
heard Mr. I.H. Soikia, learned counsel for the petition. Disaster management, ये भरोसा है जी. I'll ask Mr. Bharat standing out the disaster management. You create disaster, not revenue. A भरोसा है जी, learned standing counsel. Revenue should be in brackets. Revenue and Disaster Management Department for the respond number 1 and 4. And Mr. N. Das, learned Junior Government Advocate Assam for the respondent number 2 and 3. Posto. Para. The petitioners, 3 in number, hemp joined together to prefer the instant writ petition under Article 226 of the Constitution of India. Posto. In the writ petition, it is stated that the petitioner number 1 and the petition number 2 are owners of a parcel of land described in paragraph 2 of the writ petition. Post of as they full stop as full stop, the petition number 1 and petition number 2 have entered into an agreement for sale of the said parcel of land located in Sonai Revenue Circle District, Kachar, Assam. Full stop. After, with the petition number 3 as the proposed buyer. Full stop. After execution of the agreement for sale of the said parcel of land, the petitioners applied for land sale permission before the respondent number 3, as he is the competent authority to issue no objection certificate for land sale permission. Full stop. Under Section 21A of the Registration Act 1908, as amended by the registration within bracket Assam Amendment bracket close Act 2009 and the registration within bracket Assam Amendment bracket close Act 2021. Full stop. As per Section 21A of Section 21, amended Section 21A reaches under paragraph page 26 of the Senate. The application for land sale permission had to be submitted by the petitioners physically as in the offline mode as online application process for issuance of NOC stroke land sale permission has not yet been implemented in Kachar district till date. Full stop. The said application was receipt of the said application was acknowledged by docket number 3479 dated 5/12/2025. Correct? Paragraph 2 you have stated. Full stop. As it is amended under Section 21 of the Registration Act for the respondent number 3, either to issue no objection. Okay, 2. Okay, 2. As it is a statutory mandate under Section 21A of the Registration Act for the respondent number 2 for a jurisdictional deputy commissioner to either to issue a no objection certificate as not like containing the description of the immovable property to be transferred or to pass a speaking order with regions thereof within a period of 30 days from the date of receipt of the application in case no objection certificate is not issued within the stipulated period of 30 days. Post of para. As after submission of the application on 5/12/2025, neither no objection certificate granting sale permission for transfer of the parcel of land indicated in the application, nor a speaking order has been passed, the petitioners are before this court by the instant writ petition. Aggrieved, aggrieved there, right? The petitioner before this court by the present writ petition. Full stop. When the on 19/6/2026, the learned government advocate was asked to obtain instruction as to why the application submitted by the petitioner for NOC has not been processed to a logical conclusion till date. Post of para. Today, Mr. Das, learned junior government advocate, on receipt of instruction, written instruction, white office letter number so and so, dated 22/6/2025, has submitted that the application for the application for issuance of no objection certificate could not be processed due to incomplete filling up of the application form and deficiency of documents, namely, 1, non-encumbrance certificate, 2, NOC from co-pattadars, 3, next of kin certificate, D, affidavit from the buyer, 5, PAN card of the seller number 2, and PAN card of the purchaser. Post. Para, in response, Mr. Soikia has submitted that the petitioners are in position to submit the documents which the state respondents have stated to be deficient. Full stop. He has further submitted that if in addition to the aforementioned documents, any other document is necessary to process the application for NOC stroke sales permission, comma, the petitioners as applicants will make endeavor to submit those documents if any such communication to that effect, if any information to that effect is communicated to them. Post of para. Having regard to the stand taken by the having regard to the submissions made by the learned counsel for the parties, and considering the fact that the application of the petitioners has not been processed in view of incomplete filling up of the application form and non-submission of the documents, aforementioned documents, this court is of the considered view that instead of keeping this writ petition pending, the writ petition can be disposed of, providing an opportunity to the petitioners to fill up the application form wherever, to fill up the required columns in the application form wherever it is required, and to submit the documents, aforementioned documents before the respondent number 2 within a reasonable period of time, so that the application of the petitioner for NOC stroke sale permission can be processed to the logical conclusion by the respondent number 2 in strictly in terms of section 21A of the Registration Act as amended. It is ordered accordingly. Post of para. For the purpose of filling up the application form completely, the petitioners shall appear before at the office of the respondent number 2 within a period of 1 month, from today. And if the aforementioned documents are available with the petitioners, then they say then such documents shall be submitted at that point of time. Post of in the event all the documents, aforementioned documents are not available presently with the petitioner, and some more time period is required to obtain those, then the petitioner shall inform in writing to the respondent number 2 for extension of time period to enable them to submit those documents.
With the certified copy of this order. With the certified copy of this order. With the certified copy of this order.
Also, the petitioner shall also submit a certified copy of this order at the to the office of the respondent number 2 at the time of their appearance. Post of. If the petitioners fulfill all the requirements for issuance of fulfills all the requirements, then the respondent number 2 shall proceed to give consideration to the application in terms of section 21A of the Registration Act within the time period stipulate prescribed therein.
Second, my lord,
And this order disposes of the repetition.
only my lord, it says
Which is similar, first tell me.
4.
Okay. To a sell to 4. Who are the sellers? Who are the 1 and 2 sellers? Okay. Baki Sona revenue circle hoy.
Docket number
3 is purchaser. Docket number 3478. Date is 5/12/2025. The respondent number 2, while processing as in the notification dated 9/9/2025, the time period to process the application is same as the time period prescribed in section 21 of the Registration Act. The respondent number 2 shall complete all the formalities mentioned in the SOP notified by the notification dated 9/9/2025 within such prescribed time period.
my lord,
you mentioned 30 days.
Huh? I have said 21 days, already said 30 days.
But record may be the
Agotot. This one. Any deficient document?
my lord, this,
Okay.
4.
Okay. 3. Agot ছটা আছিল ন? এইটোত non-incumbent certificate, NOC from the co-partners,
Yes,
3,
yes, my lord.
PAN card of the purchase of the land. Not 6, huh?
No, so
Okay.
my lord, this instruction will be a part of the record. That must.
Okay, the office letter number so and so, dated so and so, placed by Mr. Das is to be kept with the as part of the case record by marking it as document. So
In
and so.
both the cases.
Both.
My lord,
Now,
here
but this is item 3.
only,
Let us
it says, my lord,
see.
only, my lord, inquiries under process as Sona. I think same problem, my lord.
Let us see. 1 and 2, seller.
1 or 2 seller.
আগৰখিনি চব একেই, খালি ইনষ্ট্ৰাকশ্যনৰ পাৰ্টটো নালাগে, ইনষ্ট্ৰাকশ্যন পাৰ্টটো নালাগে, হা? 1 to seller, docket number 3479, dated 5/12/2025, Sonai Revenue Circle. Like you waited for so and so, hence the repeat. Government Council was asked, it was today. Mr. Das, learned government book, has placed an office letter number so and so of the from the office of the respondent number 2. Comma address to him, comma, full stop. On the basis of the instruction given therein, comma, Mr. Das has submitted that by the application for NOC for land sale permission, comma, permission NOC for transfer of a parcel of land measuring 7 kothas, comma, covered by DAG number 271, 273, 278, 272, 275, 277, 278 लिखा है उसे. Under second RS patta number 85 and 86 at Moja Kazi Dahar, Part 2, PH Bonraj, Sonai Revenue Circle, District Kachar, has been sought for. Post of para. It is mentioned that as per the standard operating procedure, the said application has been forwarded to the Assistant Settlement Officer, Sonai Revenue Circle, for inquiry and report. Post of. It is mentioned that as the inquiry is under process at Sonai Revenue Circle and the same is awaited, the process of issuing the NOC could not be completed in time. Post of para. In section 21A of the Registration Act, a time period of 30 days for processing the application and to issue the no objection certificate has been prescribed. First of, in the event, no objection certificate cannot be issued within a period of 30 days from the receipt of the application. And in case no objection certificate is not issued within a stipulated period of 30 days, a speaking order with reasons has to be issued to the applicant within the stipulated period. Post of para in a notification dated 9/9/2025 of the Revenue and Disaster Management Registration Department, Government of Assam. A standard operating procedure has been laid down. Also, the notification, the relevant experts of the notification are quoted here under. Case 16, 17, page out. Under Section 21A of the Registration Act as amended, as well as in a notification, as well as in the SOP formulated by the state government, a time period of 30 days from the date of application to process the application has been prescribed. Post of para as since as per the instruction placed before this court, the application is still being processed, and treating the same as the speaking order for under the proviso to Section 21A of the Registration Act as amended.
Here also, my lord.
This writ petition is disposed of with a direction to the respondent number 2 to bring the process of bring the process to its conclusion in strict compliance of the statutory mandate contained therein. Post. If in the process, if in processing the application, any further document is necessary from the petitioners, applicants petitioners, then the respondent number 2 shall inform the applicant's petitioner in writing as regards deficiency, if any, in their application, within a time period of 15 days from today, within time period of 15 days from the date of submission of a copy of this order at his office.
15 days.
15 days, if any deficient document is there, let him communicate.
Yes.
Full stop. Disorder disposal of the petition.
Obligation.
The instruction, it will give you. Kept to the case record. All done?
5.
Yes.
In your lottery, plot of land, we get 13 Lassa, commonly known as Kaki marketing area.
What do you
I am
want
the
today?
tenant.
What do you want today?
Now your lottery, this land,
All these are disputed things.
yes, your lottery,
Will you should notice
And
this.
moreover, my lord,
notice.
as per the petitioner, it's a government land. And they have also filed application before district commissioner, but district commissioner, circle officer, none of them are party.
My grievance is that your lottery.
It is a government land.
Yes.
Land, which was allotted to one Kaki
So
marketing.
it would invite dismissal for non.
Yes, yes.
Your lottery.
For
Now, my own,
non-implementation of necessary party at a later point of time.
My lord. But my duty to point out
Uh-huh.
all things.
It is up to Mr. Mojumdar.
Yes.
yes. Now, only,
Will issue notice at this stage.
yes, your lord, my only.
Nothing more.
Let the Jilla Parishad keep the market in their position and not allowed to anybody. If they dispute, only that much I want.
Well, Gao
No,
Panchayat
it
is
is-
under Zilla Parishad only, my lord.
It will be reverted back if you have a
Yes,
good
yes.
claim.
How can they,
You are a cooperative society.
Yes.
Otherwise, you are a private body.
the process of
But
allotment?
you are a private body.
Yes. I
They
am a
are
tenant.
statutory bodies.
Yes.
That is the
Different.
main distinction between you and the panchayat.
But that land has not been allotted to Jilla Parishad. Your Lord.
Whatever, no, it is government land. You do not have any bona fide strong claim. You are a rented person. Is it not?
Obviously, but why?
Under some defunct society.
For allotment is under
I don't know
consideration.
your claim. Have you made any application for settlement of the land?
This would have several round of, I have annexed those documents. Your
Now,
Lord.
I have asked the query,
Yes, your Lord.
have you made any application for settlement of that government plot of
Your
land?
Lord, if that was under.
If
corporate-
that is not there, then how?
No, that is under-
What is your right?
Your Lordship.
What do you say that you are,
Yes,
what
yes.
what is it?
It is reflected in.
What is that
annexation E.
plant?
Annexation E.
What is that plant? Who grows on a big tree? Like beetle leaf? Right. You are a beetle leaf. You have grown on another society. That another society is defunct. Is it not?
That is defunct. Now,
Right,
I'm
Mr.
Corporation
Arpinandar,
Department.
Learned Counsel for the petitioner. Miss Bora, you are for whom?
1, 3, and 6, madam.
Okay, decide. Miss MD Bora, Learned Standing Counsel, Corporation Department for the response number 1, 3,
And 6.
6. And Mr. S. Dotto, Learned Standing Counsel for Chat and Rural Development Department for the response number 2,
2,
4,
4, 5,
5.
and 7 notice may go, my lord.
The petitioner is a society, cooperative society registered under the Assam Cooperative Societies Act 2007. And it is agreed by the action taken by the respondent number 5 in allotting
My lord.
a market,
Shit.
Huh? Market?
Market shade,
Market sales.
shade.
Looting market sales. For operation by Rani Pukuri Kambodsha,
My lord,
right?
yes,
At Kaki marketing area,
Huh?
at Kaki marketing area, which is under my.
At Kaki marketing area.
Which is under
Post
my
of.
point.
page
Where
47.
Ms. Bora and Mr. Dotto have submitted that the market sales are constructed on a government plot of land, and the petitioner society has not been allotted the said government plot of land at till date. The matter would require consideration, issue notice, returnable on so and so, as so and so appeared accepted, no formal notice, extra copies. The petitioner shall take steps for service of notice upon the response number 7 by registered post, speed post, within 2 working days from today.
0708.
I live very 17.
Item 6.
7 August.
Yes, Mr. Ahmed
Simple pair lordship the
Lokhimpur.
lordship the dismissal of the representation lordship for the
Oh, Lokhimpur disposal, digital available or non-digital?
Digital lordship.
Huh?
Digital
Kachar is
lordship.
non-digital.
It's online lordship. We have to apply
Online.
online.
So we cannot direct you. This page 42.
43, yes,
42.
42 lordship, the
That
43.
will not be sufficient perhaps.
Yes, lordship. He has to annex.
Highly digitally online.
lordship the petitioner also the online in the
Where is that?
this is not available lordship.
Not available.
Only for direction.
No direction.
Lordship the
No direction. When a mode is prescribed for doing an act in a particular manner, that must be done in a particular manner and in no other manner.
the lordship earlier filed another
You file an application. Okay. What is this? Mutation.
mutation.
A mutation. due.
Proof of death of the deceased partners in whose place mutation is sought, an affidavit swearing that the applicants are the son of.
We allow
These
dispose
are to
of
be-
this by permitting him to file.
Lordship.
Heard, Mr. N. Ahmed. Learned counsel for the petitioner.
Online apply. Notification or someone using.
Ms. N. Borlo, Revenue Department. 1.
2 and 3.
H. Sharma. Additional Senior Government Advocate. 2 and 3. Full stop. The petitioners the 2 petitioners are sons of one late Tonkeswar Gogoi. Full stop. The petitioners have stated that the petitioner's grandfather, para 2, C. Mohikanto Dihingia, alias Mohikanto Sinalaga, late Mohikanto Dihingia, alias Mohikanto Gogoi, son of Tirtheswar Dihingia, and their paternal uncle, Damodar Barukhai, alias Damodar Gogoi. The family of the, in this writ petition, the petitioners have stated that the family of the petitioners are owners of a parcel of land measuring 22 bighas, 18 lasas, covered by dag number so and so, under KP Patna number so and so, at Revenue Village Nalkata, Mauza Nakori, Subdivision, North Lakhimpur Revenue Circle District, Lakhimpur, Assam. Subject plot number 1. And another plot of land measuring 1 bigha 4 kathas, covered by dag number 689, KP Patna number so and so, at Revenue Village, Guarishali, Mojanokri, subdivision. North Lakhimpur, Circle, District Lakhimpur. Subject plot number 2. Post up. The petitioners have stated that by inheritance, they become the landowner of the aforementioned 2 subject plots. After death of their predecessors in interest. Post up. In order to get the 2 subject plots mutated in their names, the petitioners submitted a number of applications before the respondent number 3 post of as those applications for mutation have not been given consideration. The project stating that the said applications submitted for mutation have not been given consideration by the respondent number 3 till date. The petitioners are before this court by the instant writ petition, seeking inter alia direction to the respondent authorities, more particularly the respondent number 3, to consider and dispose of their applications or their application submitted on 23/12/2024 for mutation within a definite time frame. Posted. Para, both Ms. Bordolo and Mr. Sarma have submitted that the applications for mutation are found to have been submitted by the petitioner physically offline mode. Post up. After enactment of the Assam Right to Public Services Act 2012 and mutation being declared as a notified public service, any application for mutation is to be submitted in the designated portal any application. No, an application is to be submitted only in the online mode in the designated portal. Post up. Para 5. Registration, mutation, right? It is settled position of law that when you made moot, or when an act is to be done in a particular manner, then such act must be done in that particular manner and in no other manner. Post up. Para 7 bucks. No, 4 লিখি দিব, 4 লিখি দিব, 5 লিখি দিব, তাৰপিছত এই মাত্ৰ দিয়া ডিক্লেৰেশ্যনটো লিখি দিব, 7টো লিখি দিব। File online.
7,
Yes. What is the story?
Yes.
What is the story? What is the story?
Story means he says that is
He said, which dag?
regarding 625, Dag number 625.
Statement
under
meaning are not
possession of
empty.
ASTC.
As per available record, land covered by Tolji Patta number 31, dag number 625 is under possession of ASTC.
Yeah.
Further, as per revenue records and spot verification, the land under occupation of petition under falls under dag number 602, classified as NH15 reserve land, and
Not
not
under.
dag number 625 as claimed by the petition. The plot of land is not 50 meters away from the national highway. It is within 50 feet from the national highway. Now, I'm not still clear. Reserve land for NH15 or vested land for NH15.
I personally, off the record, I personally talked to him. He was trying to explain me what are his powers under Rule 18,
Rule
18 of the settlement rules.
Because my view is, if it is acquired under National Highway Act, and once it is vested in the central government, it is the highway administration. That is law.
2002 Act.
But it is reserved, not yet vested, then circle officer has jurisdiction. Slight distinction,
Yes.
but because it is central government now, and central government has to appoint, like Kala has to appoint highway administrator. And once it is identified as national highway land, there is no excuse. He is to be evicted right away. So both the powers are different. Now, what is his story? I was served with notice. So you are not sure.
I'm not sure.
But this should go.
Madam.
This notice should go
Madam.
if it is reserved for national highway.
That explanation is not satisfactory.
No, page 52.
No, I understand. But what the circle officer say is not clear how he exercises power.
So it should be if Rastar Hongrokhita Mati.
NS15 or Rastar Hongrokhita Mati.
Not vested.
Cannot be. Apparently it cannot.
Because I don't want my order to be vulnerable. Have you understood? Without knowing the facts, if it is national highway declared already, then this is unauthorized. But if it is government land still, reserved for national highway, then he is authorized. But the manner of the notice is illegal. Because he has to give 15 days notice. As per Salakuddin. So what to do? If he is at liberty to issue fresh notice, right?
Or may keep it part of record. That instruction.
That instruction, he has not spoken about highway act.
Silent, absolutely silent.
I have said Control of National Highways, Land and Traffic Act 2002.
I communicated. Along with the order, I have also written in my letter.
He has heard it for the first time, perhaps.
Perhaps.
He said government land classified as NH reserve land, government land. So we'll go by that.
Yes.
602. You are occupying 602. So this notice is not in terms of Rule 18. So we'll set it aside with liberty. If the respondent number 3 contemplates any action, that must be strictly in terms of Rule 18 and the division bench judgment in Salakut.
Fine.
That will do.
That will.
Third, Mr. M. Shoikil, Learned Counsel for the petitioner. Mr. A. Aforesaid, Learned Standing Counsel, Revenue Department for respondent number 1, and Mr. H. Sharma, Learned Senior, Additional Senior Government Advocate for the respondent number 2, 2, 4, and 6. Who is 5?
Chairman.
Para.
Principal.
Agora to Para 2. The petitioner has been served with a notice dated 6/6/2026 by the respondent number 4, whereby it has been conveyed that the petitioner is found in occupation found constructing a shop on a plot of land in whereby it has been conveyed that from a report of the concerned Lat Mondal, it has been learned that the petitioner has constructed a shop unauthorizedly on a plot of land located in Moja, Lakhimpur, not Lakhimpur Revenue Circle, which plot of land is reserved for National Highway 15. Yes, anything, Mr.
There is no mention of that number also.
Yes.
How to identify?
Full stop. By the impute notice, the petitioner has been asked to remove the shop allegedly constructed by him on such plot of land, or else he will be forcibly evicted as per the provisions of the Assam Land and Revenue Regulation. Full stop. Para. It is a case of the petitioner that the family of the petitioner, since his father is in occupation of a plot of land measuring 2 lessas, covered by Tozi Patta number 31, Dag number 625, at North Lakhimpur Sohar, part 4, Moja, Lakhimpur, North Lakhimpur Revenue Circle, District, North Lakhimpur. Full stop. Stating that the family of the petitioner is in occupation of the same subject plot since more than 33 years. It is stated. Because the petitioner has further stated that the subject plot is 50 meters away from the national highway. And the subject plot, possession of the subject plot, was taken over by the petitioner's father after executing a possessory note from the erstwhile possession. And thereafter, the family of the petitioner has been depositing Toji Bahira revenue regularly, assessed for the subject plot. After the demise of the petitioner's father,
Yes.
on 10/2/2020, the petitioner is in possession of the subject plot. With the projection that the subject plot is 50 meters away from the national highway, the petitioner has contended that the subject plot cannot be reserved for National Highway 15. Stop. At a comparable issue notice returnable as the in view of the as agreed to by the Land Council for the parties, the notice is made returnable forthwith. Stop. Para. What about your shop?
Lordship. Grocery, I think.
A petitioner has stated that the notice dated 6/6/2026 has been issued by the respondent number 4 at the instance of the respondent number 5, who had issued a notice earlier on 8/8/2024 to the petitioner to vacate the subject plot within a period of 3 days from the date of receipt of the notice. That is the case. Okay, first of para. Mr. Aforesaid ji, learned standing counsel, Revenue Department has submitted that as per instruction received by him by office letter number so and so dated so and so from the respondent number 4, comma, the land covered by Tozi Patta number 31, Dag number 625 is under possession of the Assam State Transport Corporation. Full stop. After spot verification and as per the revenue records, it is ascertained that the subject plot which is under occupation of the petitioner falls under Dag number 602 and the same is classified, has been classified as NH 15 reserve land. Full stop. Therefore, the petitioner who is in occupation of the subject plot, no, the subject plot is not under Dag number 625 as claimed by the petitioner. First, moreover, the subject plot is not 50 meters away from the national highway and it is within 50 feet away from the national highway. First stop. It is further contended that the petitioner, the family of the petitioner, and thereafter the petitioner has been paying only Bedokoli Jorimona, within bracket, encroachment penalty. And the same does not confer any right, title, or interest over the land. Full stop. It is true that payment of Tozi Wahira within bracket encroachment penalty does not confer any right, title, interest on a government plot of land. Full stop. As per the settlement rules framed under the Assam Land and Revenue Regulation 1886, only after due permission from the jurisdictional district commissioner or after acquiring the status of landowner, a person can be in person can a person gets the right, title, and interest over a plot of land. Full stop. As it is made clear, as admittedly, the plot of land which is under occupation of the petition is a government plot of land reserved for National Highway 15, any process. And if the petition is found to be an unauthorized occupant, then any process of eviction has to be initiated as per the procedure prescribed in Rule 18.2 of the settlement rules framed under the Assam Land and Revenue Regulation. First of para, the procedure to be followed for eviction of such an unauthorized occupant. Procedure to be followed for eviction of an unauthorized occupant under Rule 18.2 of the settlement rules have been laid down in the decision of a division, in a decision of the division means in
Salakuti.
Salakun versus so-and-so reported in so-and-so.
I'll give.
Full stop. Some Salakun. Salakun to আছে কোড করা আছে যদিও for the timing, notice, hearing, reply, speaking order. I'll not say so.
Fine.
Strictly in terms of so and so. For mention perhaps. তাৰ আগতে এটা rule 18 কৰি দিব 18 কৰি দিব rule 18 কোড কৰি দিব 8 কোড কৰি দিব para 8 কোড কৰি দিব rule 18 paragraph
2020.
division bench of this court in Salakuddin MD versus State of Assam and others 2024 4 GLT 857 while considering rule 18.2 of the settlement rules has entirely observed that in respect to the wasteland stroke government castland stroke estate comma etc over which no person had acquired the rights of a proprietor comma landholder or settlement holder and a indigenous person who is in occupation of such land under the disposal of the government would have a procedural legitimate expectation that before any decision to evict him, he would be given an opportunity to explain that he had a right to be considered for settlement over the land in question. Then 9. সেইটো নালাগে এনেকে লিখিলো when in the light of the prescription laid down in rule 18 of the settlement rules comma quoted above and the observations and directions made in a division bench judgment of this court in Salakuddin versus so-and-so. The impugned notice is looked at, comma, it is evidently clear that the impugned notice falls short of the requirement for the fact that the impugned notice, though purportedly issued under Rule 18.2 of the settlement rules without any description of the plot of land wherefrom the noticee is sought to be evicted, comma, is an eviction notice without providing for an opportunity to the noticee stroke petitioner to explain that he has a right to be considered for settlement of over the subject land in view of his alleged occupation. And only, how many days?
15 days.
No, here. 7 days to vacate has been given. In such view of the matter, the impugned notice dated 6/6/2026 issued by the respondent number 4 is set aside and quashed. Next para, it is made clear that setting aside and quashing of the impugned notice herein shall not preclude the competent authority to proceed again against the petitioner in accordance with law by providing a due opportunity of being heard to him, who is allegedly found in unauthorized occupation of a government wasteland, government khasland, government land reserved for National Highway 15, etc. This order disposes of the writ petition.
My instruction may be kept part of it.
The instruction placed by Mr. PROCEEDINGS, Lion Standing Council Revenue Department, is to be kept as part of the case record by marking as document X.
Okay.
So we are not saying so. Only as per Salahuddin 18(2), requirement is not met, set aside, will not preclude.
Item 8. Item number 8.
Lordship, this matter may be taken up on Friday because I could
Not Friday. I will not keep it Friday.
I could not able to complete my
Okay.
instructions.
How much is the
No, your lordship, there was no mention because.
no mention? Then it will be difficult. If there is mention, you could have. Is there any mention?
No.
Then we'll issue notice immediately after vacation.
Yes, sir.
Heard, Mr. But you must ensure.
Yes, yes.
Heard, Mr. J. Uddin,
Am I?
M. Ali, Learned Counsel for the petition, and Mr. M. Sharma,
For 1, 2, and 3.
respond number, Learned Counsel for all the respondents.
Yes.
Full stop, para. The petitioner stated that he has been maintaining savings bank account number 50170008626418 at Gauhati branch, Chirang, of the respondent Bandhan Bank. Full stop. It is a further case of the petitioner that he has been stopped from operating the savings bank account suddenly without any prior notice. As a result, the petitioner is prevented from carrying out any bank transactions. Post of where issue notice returnable on so and so, as Mrs. Sharma has appeared and accepted notice for all, no formal notice, extra copies within 2 working days. The respondent bank authorities shall ensure to place the reasons as to why the petitioner's savings bank account has been kept on hold, and if the bank account has been kept on hold due to any suspicious transaction or report in the National Cyber Crime Reporting Portal. What is the full name?
Cybercrime reporting portal.
Then the details of such suspicious transaction and or reporting is to be placed on the returnable debt.
1507.
Pendency
Are to be
cannot be,
placed.
but
I don't know.
if anything is not there, they may.
And I don't know.
1507. Item 9.
My lord, this petition is filed by the petitioner under Article 226(2), Lordship.
We'll issue notice only. That position has been changed. You have shown me something, na? On the last date?
No, Lordship, this is today first.
Okay. Heard. Which one? Why you are aggrieved?
Because Lordship, there are 3 simultaneous proceedings, Lordship, and they have chosen the Kolkata as the
Okay.
jurisdiction.
We let them appear. Chola Mandalam.
Yes,
Let them appear, then we'll ask. We can
In
ask
the
them to
meantime, Lordship,
withdraw.
the proceeding at Kolkata court, because they
I
have.
cannot stay.
Yes, Lordship, but they have already initiated Kamrup Gauhati, Lordship, and now.
That I have understood. So if those are prior proceedings, I can ask the council, why your mala-fide action? But I cannot quash that. I have a limitation. But Mr.
NH Borgulan.
NH Borval and council part of petitioner. Full stop. In this writ petition, the petition has stated that the respondent number 2, after initiating what are the other proceeding?
Lordship, the
After
synopsis-
instituting a complaint case,
synopsis, Lordship, it was stated, second para. First.
registered, which is registered as complaint case number 2537 2025 in the court of Learned Chief Judicial Magistrate, Kamrup Metro, Gauhati. And
Lordship, they have taken initiated the proceeding under Surface Act.
under section 138 of the Negotiable Instrument Act, 1881 as amended. And what service? Where is that?
Lordship, that Surface, Lordship. Under section 14, Lordship, page 35, Lordship. Under section 14 of the Surface Act, they have filed a petition before the SP, Lordship.
After initiation of actions under the SRPC full form, including steps by issuance of a demand notice under section 13(2) thereof, and taking steps under section 14 for taking over physical possession of the secured asset, the respondent number 2 has instituted a complaint case being complaint case, case number CS/347/322/25 before the Court of Learned Judicial Magistrate, 13th Court, Calcutta, West Bengal. Full stop. According to petitioner, the institution of the complaint case before the Court of Learned Judicial Magistrate, 13th Court, Calcutta, is a mala fide prosecution. Issue notice in view of 2 prior proceedings already initiated by them against the petitioner in the state of Assam. Full stop. Issue notice, returnable on soils. West Bengal not required.
Yes.
Issue notice to the respondent number 2. The notice is made returnable on so and so. The petitioner shall take steps for service of notice of the respondent number 2 by speed post within 2 working days from today, having regard to the projection made in this writ petition, notice to the respondent number 2 is not issued at this stage.
Respondent number 1. is
One,
not issued.
one.
0708, 7th August.
Hello.
Yes.
A plot of land of the petition was acquired by the National Highway Authority, my lord. And a compensation, a total compensation of rupees 81,11,372 was awarded in favor of the
National Highway.
National Highway. But my lord, before disbursement of the compensation amount, a petition was filed in the the respondent number 7, private respondent here.
Hmm?
The private respondent number 7, my lord.
Private respondent number
Seven.
7.
He
Yes.
filed a petition, my lord, in a title suit that is pending before the learned civil judge junior division at Karimganj.
Why he has instituted?
Although, my lord, the land of the petitioner is not in dispute, the suit land is different, but the private respondent number here is he is the defendant in the suit that is pending pending in the court below, my lord.
Respondent number 7.
7. He is one of the defendant.
We just, for what purpose he has instituted the suit?
He is claiming that, my lord.
So let us see your land first.
My lord. Lordship will find page number 17 is the Jamamandi copy. Petitioners are the
Page number 7.
17. 17.
Their names are there.
Yes.
What is the area of land?
Total area of land is, my lord, 16 kata, 15 gonda, my lord.
Okay, out of that entire land has been acquired or
No, only part of the land is.
how much?
That your lordship will find page number 35, my lord. Not.
Page number 30,
No, my lord, page number, my lord, 27, my lord.
27,
27.
27.
The bottom line, my lord,
This is notification under
under 3A, my lord.
3D.
3A, my lord.
No, this in pursuance of subsection so and so land space are already vested. Already vested.
Yes. But 3A notification, already vested, my lord. Even the
Already
land-
vested.
Yes.
In the settlement.
Already, my lord, land has been acquired.
Land acquired.
Land acquired.
Where is your entry?
My entry is
Page
my lord, page number
27.
27, my lord. The bottom at serial number 928, my lord. This is the land of
Serial number 1,
Nine-
2, 3, 4, 5, 6. Which one?
928, my lord, the bottom line.
Serial number.
Serial number is not mentioned. Lord.
Huh?
Page 27, serial number is not mentioned. Down below, Lordship.
Down below, my lord.
928.
Down below.
Yes, my lord.
928.
Okay, 920. That is serial number.
Yeah, this is serial number.
This is-
920,
Serial number.
Lordship.
This is serial number, my lord.
Okay, just a minute. Just a minute. Okay, DAG number 293.
293.
293.
293.
Out of that 0.0856 hectare.
Yes, my lord. Hector, my lord.
Hectare.
Hector. So,
Keep the formula ready. I'm not conversant with hectares
Lordship.
and hours.
Ours.
Lesa kotha okay.
Yes.
so my lord, the actually area measurement is slightly different from here and Kamru Metro.
Miss Bodolo, keep a chart ready.
So, my lord, here the only issue is here, my lord.
Okay, it is done. Then any award, 3G1.
Yes, but the
What
award,
is that?
that notification was issued by the district collector, my lord, that your lordship will find page number 35, my lord.
35.
Thirty.
This is notice.
Notice
Notice issued to you.
issued to us, my lord. All the
Okay.
petitioners here.
You have been recognized as title holder in accordance with the provision of so and so, compensation under so and so has been sanctioned towards cost of land. Okay, 81 lakh
81
So
lakh 11,372. Now,
sanction.
sanction
Have you received?
not received, my lord.
Not received.
Before disbursement of this amount,
Huh.
the respondent number 7, he is one of the defendant in a title suit that is pending before the civil judge number 3, junior division at Karimganj.
Respondent number 7.
7.
Okay, why he has instituted the title suit?
He has not filed the title suit, but one title suit has been filed against him. He is a defendant.
Who is the plaintiff?
Plaintiff is, my lord, your lordship will find.
What is his name? Respondent number 7. Milan Ahmed Chaudhary.
Minal Ahmed Chaudhary, my lord.
He is a defendant there.
Defendant here.
Let us see that order.
Yes. Page number 37 is the order.
What is this? Civil judge.
By this order,
Saying a petition filed by a defendant praying for not to disburse any compensation to the plaintiff. To the plaintiff means Jamila Khatun.
Jamila Khatun
Jamila Khatun is plaintiff.
is the plaintiff in
He
the-
is. She is a petitioner here? No.
No, not petitioner, because
Who is Jamila Khatun?
well, she's a separate person. She filed the suit against Minal Ahmed Chaudhary and 8 others. The suit is pending. The suit was filed in 2017. Suit is pending. The private respondent number here, he is one of the defendant in that suit.
217. Private respondent is a defendant.
Is a defendant.
Yes.
After the my lord, compensation notice was issued to us, my lord, the defendant number, the defendant, the respondent number 7, he filed a petition before the court below under order 39 rule 1 and 2, my lord, stating that the compensation amount awarded in favor of the petition that should be withheld.
You were not a party there.
I'm not a party there. I was not made a party in that shoot, my lord. Anyway, my lord, the court below, my lord, passed this order, page number 37.
What is
Directing the district commissioner to withhold the compensation amount, my lord. Now here the issue is, my lord, I'm not claiming the compensation amount before this court, my lord, because the residential building of the petitioners and the structures that were, my lord, demolished by the respondent, my lord, were also echoed by the authorities, my lord, and the JIRA that was awarded for the residential building, my lord. Only I'm claiming that part only, because I want that, my lord.
Have you made any application?
Yes, my lord. That your lordship will find the page. Lordship will find page number 12, 49.
49.
The photocopies of all the, my lord, residential building of the petitioners, my lord.
Okay.
Because the
Now, had Zirat been assessed or not assessed?
it has been assessed, but not shown separately, my lord. It has been shown with the compensation amount, not separately shown. So I want that the Zirat value that was, my lord,
But within 81 lakh that is there.
81 lakh.
But that is part of a judicial order.
No, my lord,
No, question is,
lordship.
if that entire 81 lakh has been injuncted,
Yes, ma'am.
right, by this order of before the civil judge, right, that includes the Zirat amount.
Zirat amount.
Zirat amount. That is a judicial order.
No, my lord, the court below, my lord, did not specify the Zirat and the compensation. Only the compensation part.
No, according to you, this Zirat amount is part of that 81 lakh.
It is part of the 81 lakh.
Right.
My lord.
And the entire 81 lakh
Yes, my lord.
is under this order.
Not under, not the under 81 lakh.
Where
Only
it
the-
is mentioned.
Only the compensation, my lord. Because the dispute is over land, not the residential building. The
Which
dispute is
order?
over
There is
land.
37.
Is 37, last but one paragraph, Lords.
Last but one paragraph.
It is further observed that directing the disbursement of the compensation amount at this stage may prejudice the
And
rights of the
further-
defense and affect the fair adjudication of the matter. Hence, to prevent any injustice, this court deems it necessary to restrain any disbursement of the compensation amount.
So the entire amount.
Yes.
Only compensation amount, my lord.
Compensation
That-
includes
that-
Zirat compensation. Zirat is part of the compensation. Under the National Highway Act, Zirat is part of the compensation amount. Or under the 2013 Act also.
My lord, the issue is, my lord, since the respondent number 7, they are raising the dispute about the land
I have understood.
and the
But
residential building.
81 lakh
My lord.
is the compensation amount sanctioned,
Yes, my lord.
which includes Zirat,
Zirat also.
right? And the entire amount has been put on stay, hold,
Yes, my lord.
by this judicial order,
Judicial order.
right?
Yes, my lord.
Now, out of that, you want that Zirat amount should be taken out.
Taken out from the compensation amount.
Then only option is before the civil court.
No,
Let it be clarified by the civil court, Lordship. If it is clarified, we will
You
comply.
get yourself transposed as a party in the proceeding. Because, see, Mr.
my lord.
It is a judicial order.
Lordship.
This has to be challenged
My lord.
either by entering into the arena before the civil court or under 227.
My lord.
This is if the Zirat is part of this judicial order, then 226 exercise is barred.
My lord.
Law is settled. We cannot touch this judicial order.
Lordship.
Either 227
My lord.
or you enter into the playground and play the game.
No, my lord, I'm claiming here my submission, my
I have understood. Jirat is part of that 81 lakh.
81 lakh.
Why you are not understanding
My lord.
at the same time that this 81 lakh has been put on hold?
No, not 81 lakhs. Only the compensation amount.
Don't get it clarified.
The court below, my lord, since the dispute was raised over the land.
No, then show us the petition. 363/2027. Filed before the judicial court. Show us the petition, page 37. What amount he has sought, for what amount he has sought for the injunction? On the order 39, rule 1 and 2.
Well, that petition, right now I have not brought, my lord.
No,
But-
problem is there.
But even he also did not specify the amount of compensation. But only he raised the issue.
Sir, with a judicial order, it will be very difficult unless we are clear about it. This is exercise of, this will be exercise of jurisdiction which is not vested for this court, read court. 227 is permissible, but not 226.
But that is a separate proceeding because challenging that
Oh,
order, my lord, that
we should notice.
Even your lordships may kindly come to page 41. Miscellaneous application was filed for vacation of that interim order. That was also rejected.
rejected.
Oh,
That was also rejected.
then this is a subject to 227. Petition is filed
This is not
by
under
petitioner seeking setting aside, but he is saying he is not a plaintiff.
But here, in this miscellaneous application, they have stated that this specific doc number 293 is
Oh.
not mentioned. This is different, but even then, the honorable court, the trial court did not interfere in that order.
Then
My lord.
other option is make a claim under section 3H4. Under National Highway Act, once 3Z1 is, award has been passed, then 3H4.
This is 3H4 lordship, it says.
Huh?
If any dispute arises as to the apportionment of the amount,
Huh?
here the question of apportionment is not
Entire-
there.
entire
The entire compensation amount is stated by the honorable trial court.
Normally, the only difficulty is the authorities, my lord, hold awarding the compensation, my lord.
No, 3 also.
Yes. Where several persons claim to be interested in the amount deposited under subsection 1, the,
He has already determined
yes.
that they are the title holder.
Yes.
Sanction amount. But again, that man is asking for a share.
No, actually, my lord, the only.
Response number 7.
Whether, without going through the plaint lordship, it is difficult what he is asking.
No,
for.
without going through the petition also.
Yes.
Filed by the response number
Yes,
7. If he has claimed entire amount, then
So, my lord, only my clear is, my lord, if, the Jirat amount that may be separated from the compensation.
oh, that is what I am saying, mister. Why you are not understanding? This is a judicial order passed by civil court. So 226 exercise is not permitted. 227 exercise may be permitted. You may try there. I cannot interfere with a judicial order in 226 power. That is what I have been saying. Or otherwise you will issue rule. There is no point
No, my lord,
playing an advisory role here. We'll issue rule.
no, my lord, if the notice.
Heard Mr. M.A. Islam, learned counsel for the petition.
But I am praying for dismissal of this petition, lords.
No, my lord, if the notice is.
Yes, because
if the
unless-
notice-
No, but the facts are not clear.
Well, if notice goes to the
Let
response
them,
7.
oh, no, I am. You file a copy of the petition
Well,
and the plate
well,
as an additional affidavit. I permit you.
well,
Then we'll refuse to exercise 226.
well,
But facts are not clear. Heard Mr. M.A. Islam, learned counsel for the petitioners. Miss N. Bordoloi, Revenue 1. H. Sharma, Additional Senior
234.
Government Advocate, Assam, for the response number 234. Miss R. Bora, Learned Standing Counsel, NHAI, for the response number 5 and 6. Close the petitioners have stated that they are owners of a parcel of land covered by DAG number 293 and Patta number 288, comma, located at Porgona, Kusiarkul, comma, Moja, Lakar Khai, comma, Karimganj Revenue Circle, District Karimganj. Karimganj, Fodor Revenue Circle, District Karimganj. Full stop. Out of the said parcel of land, comma, a part of it measuring 0.0857 hectare has been acquired by the central government under the National Highway Act 1956 and pursuant to a notification dated 6/3/2024 issued under Section 3D within bracket 2 of the National Highway Act. The said area of land measuring 0.0857 hectare has been 56 has been vested absolutely in a central government, free from all encumbrances. Full stop. It transfers that for such acquisition, comma, a compensation amount of rupees 81,11,372 has been assessed and full stop. Thereafter, comma, a notice was issued to the petitioners by the
LA Collector of Karimganj.
Land Acquisition Collector, Karimganj, asking, informing the petitioners that they issued a notice under the so-and-so, by the so-and-so, recognizing the petitioners as title holder of the acquired land, ask them to receive the sanction amount of rupees 81,18,372 by completing the formalities. Post op. Para. However, in view of an order passed by the Court of Learned Civil Judge Junior Division number 3, Sribhumi, in connection with a petition number 363/27 in title suit number 105 of 2017 by the respondent number 7 herein, comma, who is one of the defendants in the said title suit, comma, the learned civil judge directed the district commissioner, Sribhumi, not to disburse the compensation amount to any person until further orders from the court, from the order dated 28/2/2025. It transfers that the suit land involved in the said title suit is a plot of land under DAG number 293 and Pata number 288 at Moja Lakarkhai. Post.
Village Lakarkhai मालूम.
Village Lakarkhai, Moja Lakarkhai.
Moja Fisher Pool मालूम.
In the order, it is Lakarkhai. What can I do?
मालूम.
Post. Para. The petitioner us have approached this court by the present petition, seeking a direction to the respondent authorities, more particularly, comma, the land acquisition officer, to disburse the Zirat compensation amount in their favor.
But the representation is to the deputy commission, district commission.
But their notice is also collector,
Lodge.
not a Kala. So these are confusions.
Lodge.
You see the notice?
Yes, I have.
Poster. During the course of submission, Mr. Islam, counsel for the petitioner, has submitted that the compensation amount assessed at rupees 81 lakhs so and so comprises of the Zirat compensation. And it is that part of the compensation amount which is required to be separated from the total compensation amount for disbursement to the petitioners. So he has further submitted that the order dated 28/2/2025 passed by the Land Civil Court, when sought to be vacated by one of the plaintiffs who is still in force, Full stop. In the order dated 28/2/2025 is a judicial order. Full stop. An interference of a judicial order in a writ petition preferred under Article 226 of the Constitution of India is not permissible. Full stop. If the Zirat compensation amount is part of the total compensation amount of rupees 81 lakh, so and so, comma, then the petitioner, this court, is of the primacy view that the petition has to seek recourse to appropriate remedy permissible under the law. Full stop. Be that as it may, Mr. Islam, counsel for the petitioner, has undertaken to file an additional affidavit to bring on record the copy of the petition number 363 copy of the plaint in title suit number 105/2007 and the petition number 363/2027 filed by the respondent number 7 herein in the said title suit, in respect of which the order dated 28/2/2025 has been passed. Post of as sought for by Mr. Islam, lays the case after filing of such additional affidavit.
All right.
Mr. Islam, message is clear.
Yes.
Only an opportunity.
But only the Jiradamon I'm claiming, man.
Get the record. Then cost will be imposed if it is misled.
Item 12.
Yes.
I have to seek permission. The petitioner number 1 is my elder brother. Petitioner number 2 is myself, advocate. So my elder brother has appointed me as his advocate. Now, whether I can continue in the advocate's costume to make my submission.
That I'm also not very sure about the procedure. Yes, Ms. Burma. Mr. Das can apprise. Mr. Das.
He is in person.
BD Das.
I'm in person as petitioner number 2.
He is the petition number 2. His elder brother is petition number 1. He is an advocate by profession.
He cannot appeal. Simple.
I'm appointed by my
Espouse his own cause.
elder brother as advocate.
As espouse his own cause.
He's for
There will be difficulty.
So I will take off my gown and.
Whether in that case also it is petition in person, but he will also represent petition number 1.
He cannot represent petitioner number 1.
He has to come in person for other.
So I'll have to get my brother appoint another advocate and come with him.
Oh, 1, why 2? File separate petition.
There is an advocate appointed, but he is not a junior advocate. He is not able to make submissions, of course.
Don't complicate the matter. Engage an advocate to engage your friend. Complicate matter.
The matter may come up tomorrow, my lord.
Okay. A request is made on behalf of the petition to release the case tomorrow. Release the case accordingly tomorrow.
Item 13.
Notice maybe.
What kind of
Salary account has been freezed, my lord.
you are government employee or what?
No, my lord.
Private.
Private.
Any kind of
No information. my lord.
information?
No information.
Okay.
Bank.
You are for Axis Bank?
Yes, on the respondent lordship.
Okay. Heard Mr. M. Ali, Learned Counsel for the petition, and Mr.
A. Hussain.
A. Hussain, Learned Counsel for the all the respondents. First of the petitioner stated that he is maintaining savings bank account number para 3 at Silsor within bracket AS branch or in of the respondent Axis Bank Limited. First of the petitioner has approached this court stating that the savings bank account has been kept freezed by the respondent bank authorities without any prior notice or information to the petitioner since
Since 1/4/2026.
1/4/2026. First of the petitioner stated that he is facing difficulties as his salary gets deposited in the savings bank account and he issue notice returnable and so and so. As Mr. Hussain has appeared and accepted notice, no formal notice, extra copies, 2 working days. the respondent bank authorities shall obtain instruction to place the same before the court on the returnable date, whether the about the reasons for keeping the savings bank account of the petitioner in freeze condition. First of the instruction shall also be placed as to whether the savings bank account has been kept freeze pursuant to any instruction received from any investigating agency or due to registration of any complaint at before any authority, and the details thereof.
0708, 7th August.
Another matter, it has been taken 15/7. Can it be 15/7?
Different bank account, different issue.
Same council. Can it be?
Same petitioner.
No. Same council. Matter. Can it be preponed, my lord? His
No,
salary
not
is-
prepon, not prepon. Yes.
Obliged.
Supplementary list, item 40.
May please, your lord.
এখন কিতাপখন লোৱা মানে
I have secured the records. So far as the petitioners are concerned, they have been individually served. But they have made a, my lord, mess of the matter. I must fairly, my lord, apprise this honorable court. Form B and Form C have been served together. Form B and Form C have been served together, meaning thereby the requisition and taking over of possession. They say, my lord, since it is a drainage work, so there is urgency. So therefore, Form B and Form C.
urgency clause is there in the act. Like 17th in Land Acquisition Act.
It is there, it is not here, but.
No, it is there.
It is
But
there.
you cross the stage
Yes,
of section 4 or section 6 of the Land Acquisition Act at the stage of section 6 here.
yeah, yes,
Right.
Yes.
But where is the urgency clause?
yes, here, my lord,
Lordship, even in the
Then 4 goes.
here it is, my lord, say, section 9 is there, speedy
Okay.
acquisition of land in certain cases.
Okay.
Section 9, if lordship may be pleased to take up section 9, my lord. Speedy acquisition of land in certain cases, notwithstanding anything contained herein before, if in the opinion of the state government or the collector, it is necessary or expedient to acquire speedily any land for works or other development measures in connection with flood control and anti-erosion measures, including embankment and drainage, or for
That means the notice.
notice that now rule 4 says, rule 4 of the rules, yesterday lordship has paraphrased, my lord, that
No,
rule
but
4,
still,
yes,
Mr.
that form of
that comes after 6.
no, that,
See, 3 and 4 is about requisition.
yes,
6 acquisition. 9 acquisition.
9 is acquisition, 9
Not requisition.
not acquisition, 9 is direct acquisition. Direct acquisition. So no question of issuing notice under 3 or 4 or something, that exercise is not contemplated in section 9.
Because you have jumbled up requisition and acquisition both. requisition 3, section 3, section 4. Then the decision about acquisition at 6.
Yes.
And rule section 9 says speedy acquisition, not requisition.
Not requisition, no, not requisition. So therefore, 3 requisition, 4 taking over possession, 6 declaration. This is the simple thread laid down, my lord.
So what to do?
No.
4 should go. 3 remains.
3 remains, 3 remains.
Then some opportunity
Yes, yes.
to them.
Yes.
Thereafter you process.
Yes, absolutely, absolutely.
It is not for
No,
this
because
thing, but
that
to,
is
for the
going
rule
to-
of law.
Yes, that is going to.
Not to stop
better-
drainage
yes,
system, but the rule of law.
Even I am left with no adjectives, my lord, to add to my.
When they were served.
My lord, it is served after election, but that date itself is also not there. But it is served. They have signed it.
Yes, Mr.
They
Reka,
have-
satisfy
they have-
yourself.
Lordship, I have specifically stated in my pleadings that on 22nd of May, I have been handed over a copy of the petitions on by the Gau Pradhan. After we
Yes.
have sent after we have
Gau
sent the
Pradhan
representation to the circle officer. Lordship, we have sent the representation. We have visited the circle office on 20th of May.
So we can keep this order under 4 in abeyance, and if the petitioner files an appeal before the state government, they may file.
They may file an appeal or they may.
If they choose.
Yes, or they may prefer a representation before the collector. Because collector has the inherent power under the act to, my lord, attend to any objection.
Which one?
That is, my lord, inherent in the act itself, my lord.
Now, once order under section 3 is passed,
Yes.
then thereafter it is state government as per the statute.
It is state government, but sometimes it will quite so happen, my lord.
But that power has not been delegated.
So that power has not been delegated, but they prefer a representation before the collector.
If he has no jurisdiction.
He has no jurisdiction, but my lord, he may.
Not explicit.
Not explicit, but in cases.
But
they have
state
found-
government, 30 days, they may prefer. And state government shall take a decision. And the decision will abide by, will keep it abeyance. Order 4, order under section 4.
Order under section.
Will keep it abeyance.
Yes.
You may choose an appeal before the state government within, say,
30 days from
30
today.
days from today.
30 days from.
And state government will take a decision. And the decision taken, the order under section 4 will abide by the decision taken by the state government.
Absolutely. And then if my lord.
That is the way to protect the
Yes,
petitioner's
yes,
interest as well as the
I'm-
state
I'm-
government's
I'm
interest.
so grateful, my lord. Lordship has balanced the equities, my lord. Because I cannot.
That can only be done.
Lordship,
A drainage system is also important. Petitioner's compensation is also required.
At the end of the day, they are going
But
to
the
get
process-
quantum under 2013 Act.
And when a
Military
mode is
will-
prescribed in a particular way,
Absolutely.
that is to be.
I cannot.
One request is,
I
as the
cannot
construction
dare.
has been carried out, so some protection till the representation has been out, the appeal has been disposed. Because
So far as status quo, petitioner's plot of land. Not many.
My lord, 30, yes, yes.
Will dispose of
Yes,
by making the notice returnable forthwith. Since you have the records.
yes, my lord. Otherwise, my lord, they are substantially not prejudiced, even except, my lord, that, my lord, right to object, right to file an appeal before the
That
state government.
should
Yes,
be given.
yes.
Okay, heard Mr. K. Dekal, learned counsel for the petitioners, are Board Pujari, standing counsellor, Revenue and Disaster Management Department for the respondent number 1, Mr. A. Sharma, learned additional senior government advocate, Assam for the respondent number 2 to 3. And Miss PCA, learned counsel on behalf of Mr. R.M. Das, learned standing counsel, Water Resources Department for the respondent number 2. Post of para. Petitioners. The petitioners, 7 in number, have joined together to institute the present repetition under Articles 226 of the Constitution, stating that they have a common cause of action. Post of. para. Having regard to the subject matter involved in this writ petition and as submitted by the learned counsel for the parties, notice is issued, making the notice is issued first of as the concerned records are available from Mr. and as submitted by Mr. Borpujari, learned standing counsel revenue department and agreed to by the learned counsel for the other sides. The notice is made returnable forthwith. First of para. It is the case of the petitioners that they are landowners of periodic patta lands and they have which are located at village Gorol Moja Ramsorani, lot number 2, subdivision Gauhati district, Kamrup Metro. And they have described their plots of land in the following manner. There is a table, page 6, paragraph 3. It's a number like petition number 1, petition number. Petition number 1, petition number 2 করে দিব 10. The cause of action for the petitioners to approach this court where is Annexure 3? You said Annexure 3? Oh no, not Annexure 3. Is a notice.
Well, that is
Is an order.
135.
Is an order in Form B served upon the petitioner in connection with LA case number 4/2026. Poster on 22/05/2026. Where is the end?
Act is at
Yeah, my lord, that
Okay,
starts
order dated 7/3/2026. On 22/5/2020. First of the petitioner's names figured among the 518 notices upon whom the notice was addressed. Poster. Apart from the other than the schedule, of the lands and the boundaries. The notice reads as under page 135. Anything else served?
Form C,
Page 146.
146.
Why one is missing? 517 now. Is the lucky one. This is dated,
So the date is not mentioned in this form, say,
but when it was served?
22nd of May.
Okay,
On the same day, my lord.
on the same date.
Same day.
Another order in Form C was on the same date, 22/5/2026. Another order in Form C, purportedly under Section 4, within bracket 1, of the Assam Land, within bracket Requisition and Acquisition, bracket close Act 1964, within bracket 1964 Act, was served upon the petitioners along with others. Full stop. Apart from the description of land, comma, the content of the order passed in Form C, read as under 146. Para. It is the contention advanced on behalf of the petitioner that though power of acquisition is available with the respondent authorities under the provisions of the 1964 Act, but for requisition of land for the specific purposes laid down therein, the procedure prescribed must be adhered to, and by serving the order under Section 3(1) and Section 4(1) of the 1964 Act upon the petitioners, the petitioner has been deprived of the opportunity of making an appeal to the state government available under Section 3 within bracket 3 of the 1964 Act. Full stop. Para, in order to appreciate the such submission of the petitioners, it is relevant to refer to the provisions of Section 3 and Section 4 of the 1964 Act. First, for ready reference, they are quoted here under. First, para. A submission, which submission, Mr. Borbujari, from the rules?
Yes, my lord. From the rule, my lord, rule.
As per the Assam Land within bracket Requisition and Acquisition rules 1964.
Rule
1964 rules.
Rule
comma.
4 and 5, my lord.
An order of requisition under Section 3(1) shall be in Form B as far as may be, comma, with such modification, comma, if any, comma, as may be necessary. Full stop. An order, on the other hand, comma, an order under section 4 within bracket 1 of the 1964 Act shall be in Form C, where the surrender or delivery of possession is to be made by any person other than the collector. This is not required.
So this is
Rule
equal
5?
no, Rule 5 is equal to Form C. Now, since
Ah.
here, my lord, Form C has already been issued, Lordship is interfering.
I could quote you.
Then Rule 11, my lord.
Rule 11
Yes.
has prescribed the manner of service of the orders passed under section, has inter alia prescribed the manner of service of orders passed under section 3 within bracket 1 and section 4 within bracket 1 of the 1964 Act. Full stop. Para. A contention has been advanced on behalf of the state respondents to the effect that the 1964 Act provides for speedy acquisition of land in certain cases. Full stop. It is submitted that subsection 1 of section 9 is with a non-obstante clause. Full stop. It has prescribed that as per section 9(1), notwithstanding anything contained contained in the provisions mentioned before, if in the opinion of the state government or the collector, it is necessary or expedient to acquire speedily any land for works or other development measures in connection with flood control and anti-erosion measures, including embankment and drainage, or for the construction of border fencing and allied works, etc., the state government or the collector, by order in writing, acquired a land stating the area and boundaries thereof. Full stop. It is further submitted that the acquisition of, for the purpose of acquisition of land, the order under section 3(1) and section 4(1) have been passed for the purpose of construction of drainage system in and around Lokopriya Gopinath Bordoloi International Airport. Post of para. It is settled that requisition and acquisition are two different concepts. First of, in case of requisition, the ownership of the plot of land is retained by the landowner, where only the possession is shifted to the requiring authority. First of, on the other hand, in case of acquisition, both the ownership and possession get vested in the acquiring body. First of, from a bare person, and in case the purpose is of permanent nature, it is the process of acquisition which is expedient, not the process of requisition. First of, from a bare perusal of the order passed under section 3(1) in Form B, it is evident that the order is passed for the purpose of acquisition of land for construction of drainage system in and around LGBI airport. You have said acquisition. Full stop. Para. When in a statute, a particular mode is prescribed for doing an act, then such act is to be performed in that particular manner only and no other manner. Other manner not prescribed by the statute is illegal. Full stop. Para. In the case in hand, it is noticed, it has emerged that both the orders passed under section 3(1) and section 341 of the 1954 Act have been served upon the petitioners on 22/5/2026, and without affording any opportunity to the petitioners, as permitted by subsection 3 of section, as permitted by section 3 within bracket 3 of the 1964 Act, the respondent authorities have embarked on taking possession of the plots of land of the petitioners herein and started construction of the drainage system. Full stop. Para. It is though such infraction in the prescription, statutory prescription, is brought, or though the court has noticed the infraction of the statutory prescription, it cannot be oblivious of the fact that the purpose for which the orders under section 3(1) and section 4(1) have been passed are for construction of a drainage system in and around the airport, which is a permissible activity for requisition under the 1964 Act. Full stop. The reference to section 9 is, however, not found is not in the reference to section 9 of the 1964 Act is not of any significance, as because section 9 speaks of speedy acquisition of land in certain cases, but such speedy acquisition of land can be such decision for speedy acquisition of land can only be taken after a decision taken under section 6 of the 1964 Act which requires publication of notification in the official gazette. We'll come back.
Fine.
See, whereas section 6 is official gazette.
Because section 9 stands.
Because
independently.
4, 17(4), 6 at the same time.
Same time. Section
But
5
here no-
appears to be a standalone provision, my lord. I will,
But that is acquisition.
yes.
3 and 4 acquisition. No doubt about it. If you want to distinguish acquisition or if you assimilate acquisition and requisition, then it will be the
May it please your lordship, my lord, with the lordship permission. Item number 44, all the parties are there. My lord, can it be fixed on 16th July? It will take some
44.
time because, my lord. 44,
okay.
16th July. All the parties are present.
Okay, Mr. P.K. Raisuri, Senior Counsel appearing for the petitioners, and Mr. Ed Hall and Counsel for the respondent number 5. Had made a joint pair for listing of the case on 16 July. Mr. Miss M. Borman, Learned Junior Advocate for the state respondents are also present. As sought for by the learning counsel for the parties, list the case on switch.
The interim order to continue.
The interim order, if any, shall continue till the next better listing.
Always.
Another prayer lordship, item number 39, hearing matter lordship.
Hearing, not possible.
Yes, lordship, that is lordship after vacation fixing it.
Maybe in August. Which one? Item number?
Item number 39, the last hearing item.
Okay, on the request of Mr. J. 39. J. Kultal and counsel for the petition. Leaves the case on so and so. It is submitted there. Okay, revenue. Okay, Miss M. Borman. Done Junior Government Advocate for some and revenue A. PROCEEDINGS. R. Babujari, revenue. And 39
Yes, the revenue.
are present. Date to date.
680608.
Lodge.
Yes, any official gazette, Mr. Babujari?
Yes.
Already published
Item 40.
in this side. Okay.
Yes.
Huh? So step under 9 will be after official gazette, with the official gazette.
Yes.
Yeah, we have detail. Unka mama? Huh?
Such.
44. 44 to tell me the data division. 44, 16, 7.
In my humble submission, my lord, section 9 appears to be a standalone provision, my lord. Because that provides for direct speedy acquisition. The my lord, exercise contemplated from section 3 to section 6, my lord. It's not inculcated in section 9. So if the authority decides for speedy acquisition under section 9, it will have to publish a notification under section 9 itself, my lord. Therefore, as Lordship has rightly pointed out, my lord, that it starts with a non-obstante clause.
But it is acquisition, not requisition.
Therefore, direct acquisition.
Section 3, direct acquisition.
Direct acquisition.
Direct acquisition, anything acquisition is to be read with section 6.
So section 6.
Because it is acquisition.
Yes.
Acquisition is read with cannot be standalone, but read with section 6.
Read with section 6.
That is like section 4,
Yes.
read with section 17(4), and immediately section 6.
Section 6 of the 1890.
That
yes,
like that
yes,
only.
Yes.
It cannot be standalone.
Yes.
It must be because it is to acquire speedily.
To acquire speedy, yes.
Acquire, not
Yes,
require.
Yes, my lord, I stand corrected, yes, my lord.
That I have seen.
Yes. That's it, yes.
At the time you made submission online, I have seen it.
Yes.
It is acquisition, not requisition. Requisition has to be with a gazette notification, acquisition.
Excellent,
Requisition by an order
yes.
under 3, then followed by 4.
Yes, 4.
But
Then
acquisition, it goes permanently,
permanently, yes,
meaning that has to be by law,
yes,
and only official gazette
absolutely,
acquires the status of law.
absolute.
Otherwise, Article 300A
Yes.
by procedure.
Established by law. And necessarily it has to be followed by an award. Yes,
Once it is vested, must be award.
absolutely. Yes.
So we'll not deal with that.
Yes, ma'am.
Has noted the infraction of the statutory prescription, purpose for which orders under so and so have been passed are for construction of a drainage system in under there, which is a permissible activity for requisition under so and so. The reference to section is not of significance, as because section speaks of speedy acquisition of land in certain cases, but such decision of speedy acquisition can only be taken after decision taken under so and so, which requires publication of sorts. I have lost the link. তাৰ আগত কি আছিল? Two distinct concepts. The position is clear from Section 8 of the 1964 Act, which provides that where any land requisition under Section 3 is not acquired, then it is and is to be released from requisition, it reverts back to the owner or person interested. Reverts back to the owner in as good a condition as the land was when possession thereof was taken, subject only to the changes caused by reasonable wear and tear and irresistible force. What was the rule, manner of service of order?
That is Rule 11, my lord.
Rule 11.
While Section 3 speaks of intention to acquire. Intention about requisition. With the order. Position. Takes place with the order under Section 4. Full stop. Since by the process of serving the order under section 3(1) and section 341 simultaneously on the same date upon the petitions, comma, the petitioners are deprived of the opportunity of filing an appeal to the state government, which is a right provided under section 3(3) of the 1964 Act, comma, and a decision of the state government in such appeal has is final in the process of requisition, comma, the petitions are found to be are made deprived of the opportunity of filing such an appeal in the process. First of, in the above view of the matter, comma, this court is of the considered view that the order under section 4(1) passed in Form B shall be kept in abeyance so as to permit the petitioners to file an appeal before the state government under section 3(3) of the 1964 Act. Post of such appeal by the petitioner, if they intend to, or if the petitioners intend to file an appeal under section 3(3) of the 1964 Act, such appeal shall be filed within a period of 15 days from today, and upon receipt of such appeal, the state government shall decide the appeal as expeditiously as possible. First of, in the event no such appeal is preferred by the petitioner, then the order under section 4(1) will take effect. First of, if an appeal is filed by the petitioner within a period of 15 days, then the order passed under section 4(1) will abide by the decision taken by the state government in the appeal. Right? Full stop. So 15 days, file the appeal, right? If not filed, it will take effect. If appeal is filed, then this order will abide by the final decision taken by the state government in the appeal. Post of till and take effect. 3(1) will 4(1) will take effect. Also, final decision. Post of the parties. Parties are to maintain status quo as regards the position of the plots of appeal, plots of land of the petitioners are concerned, status quo existing as on today. As regards the petitioners, plots of land are concerned till the outcome, as till the final outcome, as mentioned here in above. Post of it is further clarified that this order is passed only in respect of the plots of lands of the petitioners are concerned.
Lordship, only one request, because as the mandate of the section 3 is 30 days, Lordship may kindly give 30.
No,
30 days from the date of service of order.
22/5,
25, that is already gone.
already gone. Whatever.
Uh,
15 days is enough.
Lordship, then one request that the records as has been obtained already.
Okay, so the records, Mr. Records of LA case number so placed by Mr. Borpujari, standing of the Revenue Department, is returned. Meaning thereby
Yes,
is returned to him. I'll make some correction.
yes, we're so grateful, my lord.
41.
It is for that, so that the proper procedure is.
No, no, Lordship has been gracious enough to balance the equities, my lord.
Item 41. Before I open my brief, I would like to just throw one revision bench jargon, only to bring to a point that there is no law or guidelines as regard putting up of hoardings or unipoles in the state of Assam, despite the order dated 2018 MPI. I'm just pointing out that. to bring to
Gadul
your
Goral.
attention. এটা তোমার টেনশন কমে Now your lordship may kindly see page 20.
Page? Yes.
Dated 23 as with reference to cited subject of book. Issuance of no objection certificate for installations of unipoles, advertisements and earning thereon. Reference to the subject cited above, I'm directed to request you kindly to take necessary steps for collections of earnings as well as giving NOC for installations of unipoles, advertisements, hoardings on the roadside of PWD road. With regard, it is mentioned here that as per direction of the Honorable Chief Minister Assam, as the land for such is borne by PWD, hence the earning from such sources should also come to the government. Now, your lordship will kindly see, I am skipping the others, page 22. As regard the petitioners, SP is the petitioner, Malak. SP Enterprise. It's a letter from the Chief Engineer PWD to the GMC. Cited above, I have the honor to inform you that the SP Enterprise so and so have requested to issue NOC for installations of unipoles in some locations of Gauhati city as per list attached herewith. In view of the above and in the light of the government letter serial numbers 2, you are requested to take necessary steps for issuance of NOC. Now, next, my lord, this is from the Deputy Commissioner of Police, page 27. I would like to inform you that the proposed locations for installations of unipoles NOC from traffic point of view may be issued for installations of 68 numbers of unipoles to SP Enterprise. That is the petitioners. And the list is at page 28 to 29.
Page?
27 to 28 to 29.
Hmm.
68 locations at different places in state in Guwahati. So
Yes.
accordingly, demand has been raised by the GMC authorities. Your lordship will find it at page 36. For the year 24-25, 84 lakhs.
Hmm. Yes.
And page 38 for the year, my lord, 25-26, 1 crore 92 lakhs.
Hmm.
I've stated in paragraph 8, my lord, the amount which has been paid.
Hmm.
Now, in these circumstances, your lordship may see the photograph also, page 46. One photograph that unipoles and mostly these advertisements are from the government only. Excepting two in the second case, all the advertisement has been provided by the government only. Now this impugn notification has been issued as page 48. Suddenly they wake up, they said, no, you issue notice, NOC for advertisements. Again, they say this, page 48. It is hereby informed that the areas under roadside dividers, medias are designated solely for tree, flowers, plantation purposes. However, it has been observed that a majority of these dividers, medians are being utilized for advertisement. This is their own advertisement, own locations. And the petitioner has spent about 4 crore, invested about 4 crore rupees besides paying taxes and all. Purposes by installations of advertisement boards, hoardings, flags, banners, signboards, pinpoles, etc. Such installations create significant traffic hazards by distracting drivers and obstructing visibility, thereby increasing the risk of accident. In view of the above, all concerned officers and staff are hereby instructed to immediately remove, installs all such advertisement boards, hoardings, flags, banners, signboards, etc. immediately. Now, your lordship will kindly see similar notification was issued, page 51A. 51A. Your lordship got it now. In pursuance of the letter received from PWD mentioned under reference, I am hereby to inform you that the unipoles installed or erected at the media of so and so by your agency are seen to be unsafe, which are creating life hazards for normal public. As such, the matter has been reviewed in its highest forum and decided for withdrawal of permission, etc. for such unipoles immediately. This is a notice issued to individual persons. So you are hereby requested to remove all the unipoles erected by your agency within days from the date of receipt of this letter. For any matter related to payments, refund, etc. for those existing unipoles erected, you may approach Gauhati Municipal Corporation regarding the same immediately. Now this was challenged this court, page 50 is the order. Agreed by the order dated so and so passed by the GMC authority, the petitioner has approached this court inter alia contending that the impugn order, if carried out, would result into a heavy financial loss and injury to the writ petitioner. By producing copies of these orders passed by this honorable court in different case, submit that in similar writ petition this court has already passed. I have passed so and so, Mr. So and so, taking note of the submissions. The learned AAG has also fairly submitted that if the unipoles are removed, then the petitioner's prayer for refund of tax, etc. shall also be looked into by the authorities. Taking into submissions of the learned counsel for the parties, I am of the view that this matter would call for some deliberation. Issue notice so and so, considering the subject matter of the writ petition and for maintaining uniformity in the judicial orders, it is hereby provided that the impugn notice so and so, insofar as it relates to the petitioner, shall remain suspended till the returnable day.
So
now-
here the petitioner is concerned with hoarding or unipole or what?
Unipoles and hoardings, both.
How many?
Yes. Well, this has been put as
Permitted 68.
68 locations.
68 locations.
Yes. 77. I have been informed, my lord. I have stated in para 8, your lordship will kindly see. We have deposited 12,41,000 and 1 crore 67 lakhs to.
No, which are permitted, 68.
68. Locations,
That
locations
pays-
are there.
Page 27,
Yes.
28.
27, 28, my lord. 68 locations. Total, my lord, ours is 77 installations in 68 different locations.
What is this page 22?
Page 22. For petitioner, my lord. 68 numbers of locations. By the deputy commissioners of police and the.
No, basically it is already chief engineer, page 22.
Yes.
So initiation was also by Public Works Department.
By the government.
Page
Now.
20. Page 20 is,
Yes, yes, paid by PWD. Then 21 is also relevant, my lord.
it is direct removal or what?
My lord.
No notice.
No notice. This is a general, anytime, my lord, the petitioner apprehensions.
Yes.
My lord, I'm just pointing out, my lord, they apprehend, anytime, my lord, your lordship knows, they have a bulldozer, they will come and then
Yes.
break it.
Yes.
My lord, I was told that all this initiation has been taken because what I learned, that because of Prime Minister of Japan visits to Assam. But now I have just come to know, it is in the flash news that this visit has been cancelled. So I think the government will change their
Yes.
stand now.
No, everything should not be related to the Japanese Prime Minister.
No, we are not concerned with Japanese.
the
Page
impugn-
20, the initiation was from Public Works.
Lordship may kindly see impugn order was dated 14th of May.
But
Now we are at the end of June.
Damocles sword is hanging.
No, if Lordship looks at the demand issued by the GMC Lordship, it was only for the year 25-26. Permission required from 3 authorities, GMC, Traffic and PWD Department.
No, it cannot be
The
on
road belongs-
whims.
Yes.
It cannot be on whims. Page 20, it is clear. Initiation was by Public Works Department.
Lordship on.
Yes, you have the power to
Yes.
keep safety,
No.
everything. I am not on that. I'm on the question that this orders must be preceded by an opportunity.
Lordship file.
Cannot
I
be a
have-
blanket
the
order.
record I have not yet seen, Lordship, but Lordship may kindly see the reason. Reason is public safety and public safety.
Absolutely.
Because very recently, Lordship, next to my house, residence, Lordship, one similar unipole boarding.
All
fell
safety
on the
measures
street,
are to be
Lordship.
there.
Yes.
But it is not that without any notice, blanket order. You
In
give,
fact, Lordship,
why it should not be replaced? At least the opportunity should be given.
no question of replacement, Lordship. Now they want to stop this practice, Lordship.
Good enough.
Yes.
That does not mean that suddenly one day you get up from the sleep, decide, allow.
Initially also.
Then
Lordship,
suddenly
Lordship,
after a few
if-
days,
if
no,
Lordship
stop.
Page 22,
No,
page
cannot be.
22. It was on the basis of an application, submitted by the petitioner.
But you
This is not
permitted
the same.
him.
This is not from
It is a
any
question of investment also.
investment up to 26, Lordship. 25, 26 GMC authority raised their demand. After 26, GMC has not raised any demand, Lordship.
But put him on notice. Because page 20, see page 20. Who had done this?
Lordship, I kindly see the subject, Lordship.
Who had done this? Public Works Department only.
Yes. No, initiation was not by the Public Works Department. Initiation.
No,
was by the
page
petitioner.
20. He may have made a
Yes.
request.
He
You
applied-
reject him.
He applied, authority given him consent, Lordship. Subsequently, now it has withdrawn. My only concern is that, Lordship, public safety.
Definitely, but at the same time, it should be a question of
No,
giving him an
petitioner's
opportunity.
Commercial interest, Lordship, should not be regarded as.
One time
something
you are
more
commercial
like
interest
public.
that earning from such sources should
We are
come to
not
the
earning.
government.
Lordship, PW department has rejected the proposal, Lordship, and PW is not earning.
No, Mr. Page 20,
That is by GMC.
no, page 20.
Yes.
If you are under that conception, page 20. GMC is not government.
Lordship, it is by the Deputy Secretary, Lordship, regarding issuance of no objection certificate.
Last line.
Last line. In this regard, it is mentioned that as per the direction of the Honorable Chief Minister of Assam, as the land of such.
Land, no,
Land
I have
for
seen fund.
Hence, the earning from such.
Fund
sources
for is borne by PSD.
Yes.
Then, hence,
the earning from such source should also come to the government, but PWD is not taking any revenue from such unipoles, Lordship. It is only by the demands are raised only by the GMC authority. So, Lordship, what I am submitting, Lordship, this is a notification of May 2026, Lordship, 14 May. Now it's more than 45 days, Lordship. So at least Lordship will give me some opportunity.
no, is it not in operation?
That is also.
That order is not in operation.
No, Lordship, if Lordship will consider if a notification of, May 14th, Lordship, if they are still working, Lordship, if they are still working, if their polls are still there, Lordship, where it was earlier, Lordship will at least give me some opportunity what prompted the authority.
Okay, definitely. I am giving in the opportunity.
Yes, but my submission will be at this stage, no interim order should be passed because Lordship will see the last interim order in the earlier writ petition laws. It was when it was granted, Lordship. It is a petition of 2020. It was granted on 21/12/2020.
We are not concerned with that.
Petition is still pending.
So you take a call. If you say,
So that
Mr.
is what I'm saying.
Nayak,
Lordship.
if you say this impugn notification is to be treated as a show cause notice,
In fact, it is not a so-called
No,
notice.
it is a notification.
Language is clear, Lord.
is to be treated,
Yes.
then I can grant them the opportunity to explain why it should not be, why that they have made investment, all this explanation, opportunity to provide explanation why it should not be acted against them. That should be provided. It is up to you.
In fact, Lordship, if Lordship.
Because if that writ petition is pending for last 4 or 5 years, right? So it is your advocate, additional advocate general. It is up to you.
And that PIL order?
But I have indicated to you.
Lordship?
I have indicated.
No. That is it. At that point
Otherwise-
of time, Lordship, what was the instruction? I'm not aware. What I'm praying, Lordship will take up this matter immediately after the on 13 itself, Lordship. Lordship
Till
will-
then, it should not act.
No, Lordship will also see, they have not made any statement that there something has been as directed, has been removed, Lordship. Where is the removal, Lordship?
Now.
Last 45 days, Lordship. Another 15 days?
Para 16. They have the apprehension.
Apprehension.
Yes, you are government. And against the might of the government, one private individual.
No, Lordship, I'm not.
Heard,
Why
Mr.
something
BD Das.
is-
I
something is-
indicated to you that if it is to be treated as a show cause
If
notice,
something is.
I can say that yes, let us have the opportunity of giving explanation.
And what will be the outcome of that so-called?
It is
notice,
up to you.
Lordship? Like, it will be futile exercise, Lordship. If the authority decided, no.
We are only on principles of natural justice. That's all.
No, only
What
question.
policy
only-
you
only-
adopt, what policy you do not adopt, it is up to you. We are not interfering with the policy.
What is the concern of the bid? It's only commercial interest. Damages, Lordship, nothing else, Lordship.
His right
Ultimately, if it
is
is a decision of the government to remove the unipoles, Lordship, government will ultimately decide. But what will concern the petitioners, Lordship? It is only the loss, Lordship.
okay.
My submission, Lordship. Nothing beyond that, Lordship. They are not.
You will
signing any-
compensate.
Lordship.
If you undertake to compensate, then I'll dispose
No,
of.
that is what. If at all,
So this requires determination.
Lordship will not determine.
I'll
what
not
will be the
determine.
compensation. Lordship.
I'll determine constitutionally.
Then in that situation,
That
Lordship, how this
Mr.
petition
B.D.
will be
Das,
maintained?
Senior Counsel, appearing for the petition as stated by Mr. Stated by the petition. Stated by Mr. D. Bonian, Learned Counsel for the petition. Mr. P. Nayak, Learned Additional
And we
Advocate
pay for
General,
1 and 2,
Assam.
Lordship.
Stated by Mr. S. Bora, Learned Standing Counsel, GMC. Post of Para. In this petition, the petition has essayed a notification dated 14/5/2026, issued by the respondent number 1, whereby it has been directed to remove stroke uninstall all advertisement boards, comma hoardings, comma flex banners, comma signboards, comma unipoles, etc. from roadside dividers, stroke medians, comma flyovers, comma ROBs, etc., which are installed in dividers, stroke medians, full stop. In the notification, comma, it is mentioned that such instruction is placed to ensure public stroke road users' safety and prevent road accident risk. And it shall apply to all categories of roads under the Assam Public, what is this, PWRD? Public Works Roads Department, Government of Assam. Full stop. Para. The petitioner has stated that he made an application who is in the advertising business, comma, submitted, represented to the respondent authorities in the Public Works Department and the Gauhati Municipal Corporation to issue no objection certificate for installation of unipoles, advertisement, etc., advertisement, comma, hoardings, etc., on the roadside of the PWD roads. Full stop. Upon consideration of the such representation, comma, the Public Works Roads Department, Public Roads Department, Public Roads Department, Public Works Road Department, the government, the state government, in the Public Works Roads Department. What is the date of this page 20? Wrote to the respondent number.
Page 21 is dated 11/8/20.
Wrote to the respondent number 2. To take necessary steps for collection of earnings as well as giving no objection certificates for installation of unipoles, advertisements, comma, hoardings, etc. on the roadside of PWD roads. Or by an office letter dated 11/8/2023. Full stop. It was mentioned that as the fund for such roads, PWD roads, is borne by the department, comma, the earning from such sources should also come to the government. Full stop. Thereafter, comma, the respondent number 2 wrote to the ZMC on 20/12/2023 to take necessary steps for issuance of NOC for installation of unipoles, advertisements, etc., and for earning of revenue from by the ZMC. Full stop. On 30/12/2023. The respondent number 2 wrote to the ZMC in reference to government letter dated 11/8/2023 to take necessary steps for issuance of NOC for installation of unipoles, etc., and for earning of revenue by the ZMC. Post of. In the with the letter dated 30/12/2023, a list of 68 locations wherein such unipoles, etc., can be installed was forwarded. Post of. Thereafter, the Deputy Commissioner of Police Traffic, Gauhati, wrote to the respondent number 2, indicating that installation of 68 number of unipoles to the petitioner can be permitted in the said 68 locations. Post of. It is the case of the petitioner. Thereafter, the petitioner installs the unipoles, etc., at 68 locations and has been depositing the demand raised by the ZMC authorities as per bills up to 2025/2026. Poster. Where the petitioner has contended that in view of the impugned notification, there is clear apprehension on the part of the petitioner that the unipoles, hoardings, etc., installed in the said 68 locations will be dismantled at any point of time, whereas the petitioner for installation of such unipoles, hoardings, etc., in the said 60 locations had invested, he has incurred a huge amount, has incurred a huge expenditure. First off, as the notification is clearly in violation of the principles of natural justice, in that no prior and reasonable opportunity was afforded to the petitioner at the petitioner could not represent as to why the any poles, hoarding, etc., installed in those 68 locations with the permission of the respondent authorities should not be dismantled. First of all, having the Mr. Now learned additional advocacy appearing for the. You represent all?
I'm appearing for 1 and 2. My friend will be appearing for 3.
Okay. লিখি দিব 1 and 2 আৰু S Bora 3 and 4 GMC standing has submitted that the notification there is no other interest other than the interest of public, other than the interest of public and safety of road users for issuing the notification dated 14/5/2026. Full stop. He has contended that the petitioner has installed the unipoles, hoardings, etc. in those 60 locations. He has submitted that from the installation of unipoles, hoardings, etc. in those 60 locations, comma, the revenue is deposited to the GMC authorities, not to the state government in the Public Works Roads Department. Full stop. A policy decision taken in the interest of public and road users' safety is clearly discernible from the impugned notification. And government, state government, is well within its authority to issue such notification. Full stop. Yes, any other submission?
That public safety and commercial interest.
That I have recorded.
That much.
But 68 only,
Yes, yes.
no else. If beyond 68, nothing.
I just wanted to bring to your lordship notice the Supreme Court judgment. When Act of Chennai, Chennai was challenged in Supreme Court, they have an act for hoardings and all. Our government did not even have a guidelines. There they said hazardous, you cannot say hazardous. There must be reason for saying hazardous.
Where the matter will require further consideration. Let notice be issued. The notice is made returnable on so and so. Who is your assisting counsel, Mr.? State by?
Pardon?
State by? You are assisted by? Assisting counsel?
Lordship, I am not a designated senior. Lordship.
No, but you are additional advocate general.
I can accept, Lordship.
Okay. As Mr. Nayak has appeared and accepted notice on behalf of the respondent 1 and 2, and Mr. Bora, Mr. Bora has appeared and accepted notice on behalf of the respondent 3 and 4. Issuance of formal notice to the said respondents is dispensed with. The learned counsel for the petitioner shall furnish requisite number of extra copies of the petition along with annexer to Mr. Nayak and Mr. Bora by tomorrow. Stop. Para. Heard the learned counsel for the petitions parties on the interim prayer. Stop. It has been brought to notice of the court that the installation of the unipoles, hoardings, etc. by the petitioner at the designated 68 locations is
77 unipoles and hoardings in 68 locations. 77 unipoles and hoardings in 68 locations. 77 unipoles and hoardings in 68 locations.
the unipoles, hoardings, etc. at the designated at 68 locations permitted by the were permitted by to the petitioner after initiation of a proposal emanating from the Public Works Road Department only. And there is no prior opportunity has been provided to the petitioner to explain as to why such posts, hoardings, etc. installed by it at those 64 locations after incurring huge expenditure should not be removed, installed. Post of privacy. There is violation of the principles of natural justice. Post of such view of the matter, it is ordered, in the interim, that the notification dated 14/5/2026 shall not be affected, EFF, shall not be made operational insofar as the enables, hoardings, etc. installed by the petitioner in the designated 68 locations in the city till the returnable date shall not be operational. Meaning thereby all you remove.
In other,
All
on
remove.
respect, on respect of petitioner.
Only.
Yes.
Since he has come to the court,
Lots.
My lord, in respect
if
to this-
there may be 1,000. There may be 1,000.
Now government will not do it.
And any other.
And the
Another
second one,
petition, second one is.
second one is, my lord, the NOC was granted on by the executive engineer on 10/10/23. 10/10/20 for
Let me
25
see.
locations.
Petitioner.
Page 24.
Petitioner, okay. Petitioner.
And by the
Initiation, same date.
same date,
Same date.
same input order.
One minute. No, impute order is same.
Same.
No. Process was
Yes, yes,
initiated.
Government
This
wanted-
first page 21 letter, same.
Same.
11/8. Okay.
Then page 24,
24.
10/10/23 by the PWD.
Okay. At a line likhibo.
Locations.
At a line likhibo. The okay. Something different.
Only two,
Then
the 2 dates.
Vinayak 1, 2. Oh,
And the page 24 and 25.
okay. So how many? 25 locations.
25 locations and 36 unipoles and votings have been put up.
We'll see 35 or 25 only.
Yes.
The location, খালি এটা লিখিব, the 25 locations have been indicated in the permission granted right letter dated 10/10/2023 for installation of unipoles and kiosks in Gauhati city. That page annexer 4. These are the locations?
Yes. And 36 unipoles and votings have been put up. We have paid taxes to the GMC.
Up to 25/26.
Yes, up to 25, 26. They will raise new one again, we'll have to pay. These are all government mallet advertising, mostly, excepting two, all are government.
So 25 plus 68.
Yeah.
Return. The respondents are to ensure that its counter affidavits are filed before the return.
0508, 5th August.
Step by tomorrow. Step by tomorrow.
Tomorrow.
Item 43.
43.
May it please your lordship.
You issue notice at this stage, hard, mister. A. Ali,
MJ Hazarika.
MJ Hazarika, Learned Counsel for a petition. N. Bordeloi, Revenue 1.
2 and 3.
H. Sharma, Additional Senior Government Advocate for the respond number 2 and 3. Seeking implementation. Agree by apparent inaction on the part of the respondent number 2 and 3 to proceed in terms of a recovery certificate issued by the respondent number 4 and 5 for recovery of an amount of rupees 66 lakh 59,212. The petitioner has approached this court by the present petition. Issue notice returnable on so and so. As Miss Bordoloi, 1, Sharma 2 and 3, no formal notice, extra copies, 2 working days, steps upon respondent number 4, 5, and 6 by speed post within 2 working days.
7th August 0708. Parted matters for admission, items 14 to 17.
Oh, we in 37. Hearing matter. That company petition.
Item 37.
Company petition. Anybody? Any other short matter? Just a minute. Any other short matter? Yes, Mr. Bhuya, you're for which item? Bhuya, you wait. You wait and Mr. Atri wait.
My matter is item number 22, my lord.
For what purpose?
My lord, this is a dispute of a bus stand operating.
That we can differ.
My lord.
We'll differ. Because we are
My lord.
into 4 other petitions
My lord, I have seen the list. My lord.
and plus
Yeah,
one
my lord,
more part matter.
My lord, I am not insisting because some other matter. So my lord can fix it immediately after the vacation.
Yes.
Some urgency is there, my lord.
Definitely will accord primacy.
My lord.
Okay, A.R. Bhuya, Senior Counsel, and Mr. M. Dotto, 1911. M. Bormon, State Respondents are present as sought for and agreed to by the Learned Council for the parties. Silas, July, Ki Dibo Pare, list the case on strength.
2407.
My lord.
Any other date except 24?
7.
What?
2707.
Obliged.
Yes, Mr. Bothagul.
Lordship, item number 55, Your Lordship. There is an IA, Your Lordship.
For what?
Your Lordship, what has happened here, Your Lordship, the petitioners, Your Lordship, who are in occupation of a particular spot of plots of land, Your Lordship. They have pattas, Your Lordship. But now the authorities says that belongs to government and they want to evict these persons to set up some hotels, etc. Your Lordship. We have been praying before them that they please demarcate the land so that we can have our land, Your Lordship, which we have all along been using for our agricultural purpose, that they say that belongs to the government. And that is why we have filed an IA, Your Lordship. If Your Lordship can take it up day after tomorrow, Your Lordship.
No, I'll not postpone anything to day after tomorrow.
Lordship. Only that is why, Your
That
Lordship,
will be headache for me.
certain urgency is there, Your
Let us see what kind of urgency.
Lordship.
45.
Only thing, Your Lordship, they have issued demarcation
Mean to do.
notices, Your
Mean
Lordship,
to do.
that has not been acted. Your Lordship may kindly see the IA. Will not take
No, I'll
much-
first see the read petition.
Lordship.
What is there in the read petition?
Lordship.
What kind of prayer?
Prayer, Your Lordship.
To conduct a proper demarcation of
Lordship.
land. But respondents are in occupation.
We are in occupation. Oh,
No.
No, we have been evicted, Your
Prior to
Lordship.
that return.
Lordship. They have evicted us, Your Lordship. That is what I am
Uh-huh.
submitting, Your Lordship.
Now what do you
Now, Your
want?
Lordship, some portion of the land, Your Lordship, they have evicted, some portion still in our possession, Your Lordship. Now, Your Lordship, our only prayer is that Your Lordship may kindly come to page 26.
Then you did not get any interim order.
No, that Your Lordship, at a relevant point of time, we have not. They are now constructing, Your Lordship. Your Lordship may kindly come to page 15 of the IA, Your Lordship. Just one communication, Your Lordship. This was dated 8/4/2025. This notice was issued by the circle officer, Your Lordship, asking us to be present there, Your Lordship, for demarcation of the measurement and demarcation of the land. Now we went there, Your Lordship. Till date, they have not done this, Your Lordship.
Yes, will issue notice, Ms. Bormon, you can
Lordship.
get the instruction
Lordship.
in what manner and within what time this process
Lordship.
measurement and demarcation of the plots of land.
Now, Your Lordship, may also kindly come to page 34, Your Lordship. These are the photographs, Your Lordship. Now, in fact, they have been started construction, Your Lordship. Now, I have annexed all the documents, Your Lordship, pattas, everything, Your Lordship, which has been there with us, Your Lordship.
They proceed, let them proceed and conclude it within a period.
Lordship.
And you submit all the documents.
Lordship, I will, Your Lordship.
But at this stage, since you have not got anything,
Lordship.
heard Mr. S. Botagul, Senior Counsel, estate by Mr. S. Day, Learned Counsel for the applicants. Petitioners. Or is Ms. N. Bodulu? Or aforesaid? Okay, aforesaid, Learned Standing Counsel, Revenue Department for the opposite party number 1, 2, 3. Opposite party does respond number 1, 2, and 3. And Ms. M. Borman, Learned Government Advocate for the opposite party number 4, 5, and 6. Name is not there. Okay.
He is not sending down, Your Lordship.
The
She appears, Your Lordship, after receipt of
the
notice.
applicants, as the writ petitioners have preferred the accompanying writ petition WBC number 1340/2025. Post of. Wherein the petitioners, applicant petitioners, have stated that they are landowner.
Landowner, Your Lordship,
Huh?
kindly come to page 8 of para 3. I have mentioned details, Your Lordship.
Nature of right. What kind of right?
Lordship, some of them has, Your Lordship, pattas, Your Lordship, Miadi pattas.
Okay.
Annual
Have-
patta.
Annual patta.
Annual patta.
Okay.
Some of them has Miadi patta, Your Lordship. First document I have shown, Your Lordship.
Annual patta,
And also allotment.
stroke periodic patta, stroke allotment holders of different parcels of land at village Hatikuli Tea Estate, Mauja Kaziranga, Bokakhat Revenue Circle,
Your Lordship,
District Golaghat, Assam. Postal. The petitioner stated that a project is being undertaken in the vicinity.
Lord, in that village and in the land, they have been under their occupation, Your Lordship. That is our case, Your Lordship.
But how we could not satisfy at the earlier point of time?
Lordship, no, Your Lordship, since Your Lordship, they have just at the very initial stage, Your Lordship, we have
A
also
project is being undertaken for construction of what?
for a hotel, Your Lordship.
For a hotel.
Five-star hotel.
In and around the plots of land wherein the petitioners were residing.
Lordship. Not using it for
Full stop.
agricultural purpose.
Huh?
Using this for agricultural purpose.
Oh, you are not residing.
Not result.
Wherein, which were used by the applicant's petitioners for
your cultivation. Your
for
Lordship.
cultivation purpose. Full stop. As the petitioner applicants petitioners have projected themselves as annual patta holders, stroke periodic patta holders, stroke allotment holders. They have apprehended that without measurement and demarcation of their plots of land, if the project of construction of the hotel is allowed to continue, and in the process, their plots of land are utilized, the situation would not be possible to be reversed.
Lord, sir.
That is your case.
Lordship, that is my case, sir.
Full stop. Para. Mr. Bodhakur, as senior counsel, has pointed out that by issuance of a notice on 8/4/2026,
25.
the opposite party, the respondent number 6, has already initiated a notice, initiated a process for measurement and demarcation of the plots of lands which are being utilized by the petitioners for cultivation purpose. And the petitioners applicants petitioners were put to notice for to participate in the measurement demarcation proceeding. But after issuance of the notice on 8/4/2025, the proceeding of the measurement and demarcation proceeding has not yet brought to a conclusion. In the meantime, the construction for the project is in progress. In the issue notice, okay, the instant interlocutory application is preferred. Seeking maintenance of status quo in respect of the plots of land claimed by the petitioners as their own at village Hatikuli until disposal of the accompanying writ petition. WPC number 1340/2025. Full stop. For having regard to the projection made in this petition in the aforesaid manner, this court is of the considered view that the respondent number 6, who had initiated the process of measurement and demarcation of the plots of land in and around the project of construction which is in progress presently, and which has the likelihood of affecting the plots of land which the applicant's petitions claim to have belonged, which are claimed by the applicant's petitioners as annual patta holders, periodic patta holders, stroke allotment holders. The respondent number 6 shall bring the process of the measurement and demarcation proceeding to a logical to an end, to a conclusion within as expeditiously as possible, preferably within a period of 1 month from today, by allowing participation of the applicant's petitioners and by also allowing them to submit all the supporting documents in support of such claim. Dispose of with the above observations and directions, with the observations made above and directions given, with the observation made and direction given above, the instant application stands disposed of. Ms. Borman, a copy of this order is to be supplied to Ms. Borman, Learned Junior Government Advocate, paying for the opposite party number so and so, to transmit the same to the opposite party number 6, so as to enable the said authority to take immediate steps from his end.
Deeply obliged.
In terms of this order, from his end.
Obliged.
Main two. Okay, as Thakur, senior counsel stated by so and so. Other parties, yes, somebody appeared, yes, you were there. You were for whom?
Hearing on behalf of P. Barwa, Your Lordship. She
P.
appeared.
Borua.
Yes, Your Lordship.
Your name, please.
S.T. Khan, Your Lordship.
On Learned Counsel on behalf of Ms. P. Borua, Learned Counsel for the opposite party, that's response number 7.
Your Lordship, if I may please. We have not been served with a writ petition, Your Lordship.
Okay, as Thakur, Learned Senior Counsel stated by as they, Learned Counsel for the petitioners, Ms. M. Borman. Okay, revenue. A aforesaid revenue 1 to 3. M. Borman 2, 4 and 6. Miss
S.T. Khan, Your Lordship.
Miss S.D. Khan, Learned Counsel, appearing on behalf of Miss P. Borua, Learned Counsel for the response number 7, has submitted that a copy of the writ petition may be furnished to her for filing to respond to the writ petition by way of filing a counter affidavit. Mr. Day, Learned Counsel for the petitioner, shall furnish a copy of the writ petition to Miss So-and-so by tomorrow. Lays the case. After 4 weeks, the respondents are to ensure that their counter affidavits are filed before the returnable date.
Much obliged, Your Lordship.
Good. Yes. Let us then start. Let us then start 14, 15, otherwise to. Yes, who are there in the other cases? Mr. Chaudhary, I did not see you. I'll not take up this.
I thought so.
Right.
I thought so.
So leave the case before any other matters without me. I look for you from 10:30.
I wish it is my misfortune. I would have been free earlier.
Okay. Yes. What are you were there?
My lord.
I'll not record names. Yes.
My lord.
Other?
46 lordship.
Yes.
Some urgency lordship,
What kind of urgency?
because it's a bona fide certificate and the transfer certificate, 2 kids were sought for.
Bona fide. What is the item number? Yes.
And on the last
In the
occasion,
process, I lose time for the main cases, for which
on the last occasion.
everybody has urgency, sir.
Last occasions were directed to serve the notice upon the respondent 3, 4 and 5 to trustee mode and accordingly.
Who appears for the respondents?
I'm appearing for respondent numbers 4 and 5.
4 and 5. Who are you?
We are the Kendriya Vidyalaya Sangathan where the child was studying, the children were studying.
Okay. What difficulty you have?
Lordship, the only difficulty is we do not know whether there seems to be some dispute between the husband and the wife. Now, neither of them has clarified their stand whether there are any orders from any courts with regard to the custody of the children or where they should be studying. If both of them clarify that position, let the husband appear, Your Lordships, and let him also. Oh, okay.
Yesterday, Lordship, I have received the notice, dusty notice yesterday. And today we have filed the Wakalatnama, Lordship. That is heading there because it's a loss of education of my children, minor children, Lordship. She has left the matrimonial home without intimating the husband. There are material suppression of material, suppression of material facts.
Suppression is different thing, but it is the custody of the child. How old are they?
10 years and 7 years.
Lordship, this is
Same.
with regard to custody of the child. What they're asking for us is for a TC, for a transfer certificate.
Right, now you are demanding.
Yes, so the
No, no,
problem.
you have said
Yes, Your Lordship, the difficulty on our part is that we do not know.
that is what.
Who's the guardian or the custodian of the child. And that's why we're not being able to issue the TC. So that is the only difficulty.
Yes, what
As
is
long
your
as-
take?
Yes, yes, Lordship, they were studying because the only fact that my children, minor children got admission because of my service that I'm serving as a chief manager in the Union Bank of India, Lordship, PSU, which is regulated by the guideline. There is a KV's guideline, Lordship, there is a guideline and where any of the parents.
But both of you are estranged now.
Yes, no,
Yes.
Lordship, she has just.
Estranged.
Yes, from March.
There
we
is
are-
estranged relationship. Is it not?
Lordship,
Sign of admissions up to me.
yes, everything, the admission, they have been admitted. for
Mr.
Indian
Ray, he has
academic
appeared today. You have to give some time.
Yes, yes.
On
Lordship.
15th of July, Lordship.
You respond.
Because-
Because 16.
And now it is summer holidays.
Yes, Lordship.
No class is lost.
Can it be on 16th? Lordship?
16th,
What 16?
16th of July. Lordship.
Immediately after reopen.
Thursday.
No Thursday.
7.
15th.
And 20th,
17.
20th.
17.
17.
Heard Mr. S. Deka, Learned Counsel for the petition. All have appeared now.
Now
Yes,
it's-
Miss. Who is for 1 and 2?
1 and 2 is the Union of India and the.
Miss.
Yes.
Miss? You are for response number 1, Learned Central Government Council. For the response number 1, Miss R. Bora, Learned Standing Council. Learned Central Government Council or Standing Council? Okay. Standing Council, CPSC, for the response number 2. Miss Chaudhary, you have earlier entered appearance or today?
First
Okay. Miss R. H. Chaudhary, Learned Council, has submitted that she represents the respondent number 4 and 5. And Mr.
H. Mujumdar, Your Lordship.
Learned Council has submitted that he represents the respondent number 3. Full stop. As all the respondents are represented by Learned Council, comma, let the case be listed on 17/7/2026. The respondents, more particularly,
3.
the respondent number 3 and the respondent number 4 and 5.
5 is there. 5 is no.
Four are to bring their stand in the matter involved in this petition by way of counter affidavits before the returnable date.
Endeavor shall be made on for disposal and settlement.
That we always try.
Much obliged. Much obliged.
Items 14 to 17.
Hey, already dictated part to what? Already dictated part to. Make it a very joke, eh? It is difficult before holidays.
That is there.
Whatever possible.
Yes. Very-
Then otherwise we'll put it again tomorrow, but before holiday I'll dispose of.
very-
মই এই হেৰিখিনি গুচাই দিওঁ ইফালে ইফালে আৰু বসুন্ধৰা তাত আছিল সেইটো কানেকশ্যনটো ক'ত আছে বা Mr. Bhuya, we'll try. Right, no, otherwise tomorrow, but before holiday, I am trying to dispose of. I'll not keep it.
What can we keep it, CAV?
No CAV. No CAV.
Lordship, probably.
I do not want to
Half of the
spend
portion,
a sleepless night during vacation.
half of the portion has been dictated by Lordship in open court.
Time permits, I'll conclude.
Lots.
I'll say close. Then, therefore, I may dictate it in the chamber also, but no CAV.
And we have already conceded to their.
No, conceding is different thing. But legal issue is different thing.
Lordship.
By conceding, you cannot dilute a statutory
No,
provision.
regarding the.
Well, I have looked into it, but serious issues.
Lordship. Not today, Lordship.
May not be.
Not-
If I think that I am in a position to dispose of, I'll close.
Lordship.
Or otherwise tomorrow.
Lordship.
Somehow I'll close.
Dictated. Okay.
Let me refresh first. শিরোনাম পাইছো? Your submission to us. Okay. It was para 7 or likhibo. Huh? Para 7. Mr. Atra. Learned counsel for the petitions. Has submitted that the review board, while giving consideration to the proposals, comma, did not give consideration to the relevant factors which were required to be considered for grant of remission.
24.
First of, he has submitted that the factors germane for grant of remission are mentioned by the Honorable Supreme Court in the case of Laxman Naskar versus State of West Bengal. Full stop. Additional factors are also mentioned in an office memorandum dated 16/2025, issued by the state government. Full stop. The review board has given has taken into consideration as regards taken into consideration on the offense committed by the petitioners in how many cases? 3 of the cases.
3 cases.
In 3 of the cases. And in the opinion of the presiding judge in the other case. Full stop. He has contended that heinous nature of the offense cannot be the sole factor for rejection of a proposal for remission, as observed by the Honorable Supreme Court in the case of Rohit Chaturvedi versus State of Uttarakhand 2026, SCC online SC 865. Full stop. He has further pointed out that the review board had considered all the permission proposals at one go and not on the case-to-case basis as mandated by the office memorandum dated 6/10/2015. Full stop. In the case of the petitioner, Samsul Mia, the proposal ought to have been considered on the ground of parity, as the co-accused who was convicted along with the said petitioner was granted remission.
Granted remission. Remission, Lordship.
Remission.
Yes, yes.
Granted remission. Full stop. On the ground of parity, Mr. Atra has referred to the case titled Jaswant Singh versus State of Chhattisgarh, 2023, 17 SCC 297. Full stop. As the opinion of the presiding judge in the case of the petitioner, Muhammad Moinuddin, was that was neither in favor nor against.
Nor against.
What
No
do you say?
expression.
Was indefinite.
Was it?
Was indefinite. The proper course for the state government to be adopted was to call for a fresh opinion. Full stop. Insofar as the case of the petitioner, Holiram Bordolu is concerned, when the proposal was considered by the revenue board or review board on which date?
19/3/2026.
19/3/2026. The said petitioner was already above 75 years of age, and therefore that the age of the petitioner was also a relevant factor for considering a proposal for remission. But, the review board did not give any consideration to the age of the said petitioner. Where? Until last thought, last thought. Please take your seat.
Yes.
As mentioned in above, the proposals for remission this Holiram was considered on 22/7?
During the pendency of
No,
the proceedings.
No, but 22/7, his case was not considered.
That lordship is not clear. It is. Because unlike the other cases, there is no communication in the case of Holiram.
Ganesh Bhumi is different. Okay. Were considered by the review board on 22/7/2024. Along with 72 number of other proposals for remission. Full stop. The review board stated to have discussed the merits stroke demerits of each proposal. Threadbare and recorded its decisions. Full stop. Insofar as the petitioners, namely one, Mohammad Moinuddin, one, no, Samsul Mi, then two, Mohammad Moinuddin, and three, Ganesh Bhumis are concerned. The review board recorded the decision and reasons thereof in the following words. ER+I. Serial number প্রথমতে হবো 21. তাৰ তলত 20, then তাৰ তলত 75. In the meeting of the review board held on 19/3/2026, so the meeting of the review board convened on 19/6/2026 to re-examine the cases of remission in respect of 32 life convicts for the year 2025 and to review the cases of 58 inmates undergoing sentence of life imprisonment and to recommend their premature release as per the guidelines given in the office memorandum dated 6/10/2015. Full stop. As per the minutes of the meetings, the review board stated to have followed the direction of the Honorable Supreme Court in Sangit Supra and the guidelines in the office memorandum dated 6/10/2015. Full stop. As per the minutes, the review board confined its consideration to fewer proposals and only exceptional cases of life convicts like terminally ill patients, cancer patients, etc., or who has completed the stipulated 14/20 years of imprisonments were considered. Full stop. The review board was of the view that good behavior alone could not be the criteria for premature release of life convicts. And was of the opinion that life convicts should not be recommended for release just after completion of 14/20 years and should not be considered for remission unless it falls in the exceptional category. Full stop. After the review board purportedly after giving consideration to the merits stroke demerits of each proposal and after a threadbare discussion had only decided to recommend a proposal for remission in case of only one life convict, aged about 15 years, who was found to be suffering from cerebrovascular issues, making him paralyzed, which had made him paralyzed. First up, the review board returned 32 number of proposals received for the year 2025 and 57 number of proposals for the year 2026 to the Inspector of Prisons with a direction to resubmit the proposals after proper application of mine following the directions of the Honorable Supreme Court. Full stop. From the minutes of the review board dated 19/3/2026 of the review board, it is evidently clear that the proposals for remission were not considered on case-to-case basis, and the proposals other than the one particular life convict, were considered on wholesome basis as no separate reasons are recorded in case of '89 proposals for remissions of life convict placed before the review board on 19/3/2026. First up. Itu এটা mark করা আছে 22/7/2024, huh? Serial number 2021 something. From the regions recorded by the review board in case of the three petitioners, Samsul Mia, Moinuddin, and Ganesh Thumis. It is eminently clear that the proposal for remission in the cases of Samsul Mia and Ganesh Bhumis were deferred by 2 years only for the reason that the nature of the crime, according to review board, was heinous in nature. Posto. Besides, Posto, the review board recorded that that Samsul Mia was the prime accused, that is Totamia, along with Totamia. Okay. Samsul Mia was the prime accused, whereas Samsul Mia got the petition in so and so. And whereas Ganesh Bhumis was involved in the crime of kidnapping and murder of a minor. Posto. As regards the proposal for the petitioner, Moinuddin, the review board deferred consideration on the premise that the opinion from the presiding judge was not clear. Posto. It has been held in Ramchandar Supra to the effect that the appropriate government is not required to follow the opinion of the presiding judge mechanically. Full stop. If the opinion of the presiding judge does not comply with the requirement of section 432 within bracket 2 CRPC, or if the judge does not consider, if the presiding judge does not consider the relevant factors for grant of remission that have been laid down in Lakshman Naskar Supra, the government can request the presiding judge to consider the matter afresh. Full stop. Which proposal was, which proposal was? Neither here nor there, presiding judge.
Lordship, in the case of Moinuddin, at page 74.
In the opinion given by the presiding judge on 29/5/2021, in case of the petitioner in WPC number 5999, the presiding judge mentioned that he could not say whether the remission was to be given to the petitioner or not. And he had nothing to say whether the sentence of life imprisonment imposed on the petitioner was to be commuted or not. The said opinion of the presiding judge, in the considered view of this court, is neither here nor there, and is not a definite opinion, and it can be and is not, and it can be said to be a definite opinion which considered the factors laid down in Lakshman Naskar. Post up. A duty is an obligation is cast in the event of receipt of such an opinion, an obligation is cast on the appropriate government, and for that matter, the review board to request the presiding judge to consider the matter of the petitioner afresh in the light of the relevant factors and to give a fresh opinion. Full stop. In the case of the petitioner, in 6283/2025, the review board did not ask for a fresh opinion from the presiding judge and had Ganesh Bhumis, right?
No, Lordship, that is Moinuddin, 5999.
5333. Oh, but okay. What I read then?
Lordship dictated 6283. That number will be 588.
Okay, that is okay. This is Ganesh Bhumis.
Yes.
What I was dictating are the facts of Ganesh Bhumis.
No, Lordship has dictated the facts of Moinuddin. The number 6283 is the number of Ganesh Bhumis. The opinion is not clear in the case of Moinuddin.
Okay, but 74. 74 of Samsuddin or Moinuddin.
Point. 5 triple.
Okay. 599. Hmm? Last line to keep, follow. From the presiding judge and had simply deferred the proposal on the recording the reason that the opinion of the presiding judge was not clear. Full stop. The opinion of the presiding judge and similarly, comma, the decision of the review board in view of the provisions of section 43(2) CRPC must be accompanied by reasons. Which should be demonstrative of the fact that the authority had given due consideration to the relevant factors and the reasons must not be mechanical. Full stop. It has been held in Ramchandra that an opinion accompanied by inadequate reasoning would not satisfy the requirements of section 432 CRPC, and it would not serve the purpose for which the exercise under section 432(2) is to be undertaken. Full stop. Para. From the region assigned by the review board, in the case of the petitioner in অন্যদিন তো হয়ে যাবে। In WPC number 524. It will. 524 is Holiram. I get confused with the names. Where is it office memorandum? In Holiram, it is annexed.
Yes, Lord. At page 41.
The presiding judge, in his opinion rendered on 29/3/2025,
25.
had opined that the case can be considered for remission. Full stop. He is 75.
76.
Where is that? 41, right?
Yes, Lord.
Which clause?
6A, paragraph 6A. Last paragraph.
Paragraph 6, small a. Of the office memorandum has enumerated that while taking decision, the state government, and for that matter, the review board, shall have regard to the case of a convict who is older than, who is more than 75 years and privacy would not pose any threat to the society as per the finding of a medical board. Full stop. The petitioner at the time of consideration of his proposal for remission on 19/3/2026 is admittedly above 75 years and it is a policy decision of the state government that in case of a convict aged above 75 years, an opinion is to be obtained from the medical board as regards likelihood of posing any threat by such convict to the society in the event remission is granted. Full stop. Admittedly, no opinion from the medical board was obtained by the revenue board prior to giving consideration of the proposal for remission in case of the petitioner, and no reason was assigned as to why his case for remission. Even after he is above 75 years of age, cannot be considered. This is Ganesh Bhumich.
This is Holy Ram.
Sorry, Holira. Ganesh good. Huh? Review. Review board. Review board लिखो हाँ. ऊपर क्या बेलग हो जाए? हाँ? 19/3/2026. Huh?
29/3/2026.
Date of the opinion.
19/3.
29/3/25. Lordship, the opinion of the judge.
Oh, opinion of the judge. Opinion of the judge, huh? Presiding judge. Then what about Sapsul Mia?
Opinion is at page 88.
88. What is Jaswant Singh?
Jaswant Singh on ground of parity. Lordship.
Citation. Citation go. Jaswant, just one, no? I to assess. Who are heinous crime?
Lordship, Ganesh Bhumich, Samsul Mia, and Holy Ram Bordolo is that wholesale rejection. So
The prime reason for differing, all are deferred?
all are deferred. Lordship,
The differing the consideration the proposals in case of the petitioners in petitioners in
item number 14, Ganesh Bhumich, item number 15, Samsul Mia, and Lordship, thereafter, Holy Ram Bordolo is that wholesale rejection. So perhaps.
and দুটা লিখলে হবে comma is the heinous nature of the crime. Where is Justice Nagaratna's judgment?
Yes, Rohit Chaturvedi.
Rohit. In which para?
Para 7 and 7.1.
7.1. The Honorable Supreme Court in Rohit Chaturvedi versus the State of Uttarakhand, 2026 SCC online, SC 865, has observed that the nature of the offense, cannot be the sole ground for denying remission. The decision on remission must emerge from a holistic assessment of the prisoner and after balancing societal interest with the prisoner's right to be considered for release on fair and reasonable criteria. Which are already outlined in the case of Lakshman Naskar.
Lakshman Naskar.
Post of Supra. Post. Just want to go.
if as far as Samsul Mia is concerned.
No, just one Samsul, Samsul.
Yes, there is the grounder parity, serial, they were both considered in the same meeting, 20 to 7/24.
Samsul. Oh, Samsul, yes. Yes. By the same judgment in order of conviction and sentence, the trial court had convicted one Tota Mia with the petitioner in WBC number 5946/2025. First of, both Tota Mia and the petitioner were sentenced to undergo rigorous imprisonment for life and to pay a fine of rupees 4,000 with default stipulation. Additionally, the petitioner was sentenced to undergo rigorous imprisonment for 6 months and to pay a fine with default stipulation for the offense under section 498A IPC. Agora 302 IPC. Post of. The sentences were ordered to run concurrently. Post of, meaning thereby, the petitioner had already served out the sentence imposed on him for the offense under section 498A. Post of. Insofar as the offense of murder under section 302 IPC is concerned, both the petitioner and Tota Mia were sentenced similarly. Post of. Which para? Jagdish?
Yes, sir.
Or just one?
That's one para 8 and 9, Lordship.
Tota Mia was granted remission.
Yes,
When?
20 to 7/24, the same meeting that is considered.
The proposals of both the petitioner and Tota Mia were placed before the review board on 22/7/2024. Post of. While deferring the proposal in case of the petitioner, the review board allowed the proposal for remission submitted for Tota Mia. Post of. Pera. In a case of similar nature, the Honorable Supreme Court in Response Singh and others versus State of Chhattisgarh and another 2023 17 SCC 297 finding the case of the petitioner therein with the co-accused who were granted remission, comma, directed the petitioner's application for remission for reconsideration by the government affairs. After obtaining an opinion from the presiding judge, as the presiding judge's opinion was not after consideration of the relevant factors. First of all, who remains?
Lordship is covered. All four have been covered. Lordship.
Huh?
Lordship is covered all four.
All four.
With respect to Ganesh Bhumij, perhaps Lordship Ganesh Bhumij, Lordship has not perhaps looked into the documents, perhaps that maybe.
Ah, Ganesh Bhumis.
Yes.
Ganesh Bhumis.
6283.
Itu nih. Itu. In case of the petitioner in WBC number 6283, 2025, comma,
Page 60 is the opinion.
this is the division bench remission, leniency, no,
No, not this Lordship. That is Holy Ram.
page,
60 is the opinion. Lordship.
the presiding judge's opinion of the presiding judge contains nothing adverse against the petitioner and records no objection in case of a remission of the sentence by the state government in its discretion under section 432 within bracket 2 CRPC. He is heinous.
Heinous.
Post. Any other peculiar factor? Ganesh Bhumi?
Lordship, only one aspect, Ganesh Bhumij, it says heinous crime of kidnapping and murdering of a minor child.
That has been taken care of. তাতে তেনে গণেশ ভূমিষ্ঠ দি দিব বাকী দুটাৰ লগত এটা দিছিল ন তাৰ লগত আৰু তো গণেশ ভূমিটো দি দিব হেনিয়াছ কাইণ্ড
Samsudin.
শামসুদ্দিনৰ লগত কিবা আছিল fair from the discussion made above and the regions assigned recorded therein, comma, it, the cases, the proposals for remission in case of these four petitioners were not given consideration by the review board who are all the relevant factors required to be given consideration at the time of consideration of such proposals for remission. First of the factors which are germane for consideration of a proposal for remission have been outlined in the office memorandum dated 2025 and the line of decisions of the Honorable Supreme Court discussed herein above. Full stop. In such view of the matter, comma, this court is of the view that the petitioners, PS, proposal for remission are to be given reconsideration by the review board, AFRES. Full stop. Therefore, the Inspector General Prisons, Assam, is directed to place the proposals of remission of these 4 petitioners before the review board as expeditiously as possible and within the month of July 2026. It is anyway going to be held. Full stop. The respondent authority, the respondents, the state respondents, are also directed to obtain an opinion. Face opinion from the presiding judge not required, only in case of
Only in case where it is.
that one. Who is that one?
Moinuddin,
Opinion
599.
on the proposal for remission. In the case of the petitioner, WBC number
5999.
from the presiding judge, AFRES, who in turn is to furnish the opinion accompanied by after taking into consideration all the relevant factors that govern the grant of remission and with adequate reasoning. Within the shortest possible time on receipt of any information in this regard from the Inspector General of Prisons, Assam. This court reiterates that consideration of the proposals for remission of these 4 petitions by the review board shall be upon consideration of all the relevant factors that govern the grant of remission, including the office memorandum dated 16/2015 strictly. First off, the final decision on the petitioner's proposal for remission is to be the final taken on the proposals for remission of these 4 petitioners are to be communicated. Some national
NALSA policy, Lordship.
Huh, huh,
NALSA SOP.
huh,
Provide a copy.
is to be communicated to the petitioners. Somewhere it is there, I have seen.
Yes.
Justice Okar judgment. Let me see. Is there somewhere? To be immediately communicated to the petitioners, to the office of the concerned prison. Post of the copies thereof should also be forwarded to the secretaries of the concerned district legal service authorities, right?
Yes.
As per the policy, NALSA policy,
Yes, Lordship. Lordship, also just one more aspect that NALSA SOP has been made binding by Justice Okar's judgment, which I'm just handing over, Lordship.
in re-policy,
Yes, yes.
as per the SOP issued by the National Legal Services Authority, comma, the prison authorities shall inform the petitioners that they have the right to challenge the order of rejection of the prayer for the grant of remission. So, this will do
Yes. Deeply obliged.
with the observations made and the directions given above, comma, all the 4 petitions are disposed of.
Obliged.
You'll not get it today, tomorrow. Madam, you communicate after getting a copy so that this review board can be constituted.
Right.
So good homework on your part.
Grateful.
Oh, 4:30. Yes, Mr. Bhuya, actually, sorry. By this time. Tomorrow we'll do it. We'll dispose of. Yes, sir. Tomorrow. Due to paucity of time, the case could not be taken up today. I'll raise the case tomorrow. To item number
34.
30. Others?
Much obliged, Your Lordship.